Criminal petition
Next date before the learned court below is on 27th. With someone.
on 26th. Today is on 26th.
25th is holiday.
Okay, it's
Most of the.
Similar prayer, my lord, for listing criminal petition on 29, my lord. On Friday, my next Friday.
May I please, madam? I beg to mention item number 22, madam. I am for the respondents, madam. I have taken the consent. I pray that this matter may come up on first of September, madam.
22, no? First,
22.
as agreed by learned counsel for both the parties, list the matter on 1st of September.
Obliged. Okay.
Maybe, Your Lordship, I beg to mention item number 11. Kindly pass over for the day.
Learned counsel, Mr.
As new.
S. Medi,
As new.
S. New,
Yes.
has requested to pass over this matter for the day.
Much of this.
Sir, I have a prayer for item number 40. Item number 47, my lord. Pass over day, my kindly, my lord, and can we do, my lord, 27th, my lord? Item number 47 motion.
M. Doctor, no?
My lord.
Learned counsel, Mr. M. Doctor, has prayed for adjournment, list the matter on 29.
There's some urgency in the matter, ma'am. So can it be on 20?
On
20,
28.
then it will be 20. Let it be 29th. then.
29.
27.
May it please, Your Lordships. Also, sir, beg to mention for listing of a criminal revision petition.
Hmm.
Any date next to mine.
Criminal. 29.
Obliged, Mr.
I have to mention for criminal petition, my lord.
Hmm.
For hearing. Next week, my lord. Any day?
Next week, any date. 29.
20 next week. First week. No, first week of September. Obliged, man.
Wait, please, Lordship. I beg to mention for listing of an IA, Lordship, IA criminal. 9th day of September, can it be possible, Lordship? 9th September. Obliged, Lordship.
May it please, Your Lordship. Lordship, for listing one criminal petition, any date on next week.
Next week, any day next week. Criminal petition.
Criminal petition.
I beg to mention for listing criminal petition.
Hmm.
May it be the Lordship. I am praying for listing of a IA, Lordship. In the
IA in connection with?
IA in criminal appeal, that is for suspension of sentence. Appeal may be,
Yes. Lordship, I beg to mention a criminal revision petition, Lordship, for listing, Lordship.
May I please, Your Lordship. Lordship, for IA, Lordship, for bail, Lordship.
IA for bail. Not here, not here. Not here.
May I please, Your Lordship. Lordship, I beg to mention a matter from yesterday's cause list which could not raise before court number 14. Criminal revision petition, my lords. It is for a short issue. Criminal revision has already been allowed. The problem is that, my lord, a recall of non-bailable warrant was there, which was posted yesterday before court number 14, my lords. If that may come today as an unlisted matter, my lords, we will go for a very short issue, my lords. Only for recall of NPW.
Not today.
Then at least 27 minutes.
Okay, on 27.
I'm so obliged, my lords.
May I please, Your Lordship, I'd like to mention item number 3 and 4, Your Lordship.
Hmm.
Similar matters have been listed on 27/8, Your Lordship.
Hmm.
This matter may also be listed on 27/8, Your Lordship.
Fine. 27. Similar matter, huh?
Similar matter, Your Lordship.
3 and 4.
3 and 4.
Learned counsel, Ms. S. Nazni, has prayed for adjournment. List the matter on 20, along with what?
Along with, may I say the
Yes,
case numbers, Your Lordship?
Not item number.
Case numbers, criminal revision number 312/25, revision 334/25, 335/25, 337/25, 336/25, 337/25. Obliged,
May I
Your
please, Your Lordship. Lordship, the one revision petition, Lordship. IA for convention of sentences, Lordship. Any date, Lordship. It's
I'm sorry, Lordship. Item number 11, can you fix on 3rd September?
Can on 3rd September, yes.
Mass of this.
Your Lordship, I beg to mention
11.
the listing of a criminal revision petition, Lordship, in motion column. Lordship, kindly sort it
Short date was
for September. Lordship, urgency is that, Lordship, already evidences were completed, Lordship.
finally.
28 August.
Item number 1 for motion.
It's a criminal revision petition for Jimma of a vehicle, Your Worship,
Mm.
where it was seized under NDPS Act. But the driver of the said vehicle is the
We need
accused.
the report from the IA.
Yes.
It's under investigation
No,
or?
the trial has been completed, Your Worship, and the driver, the accused person has been convicted. I am the owner of the vehicle. Whereas I have nothing to do with it, I am not the accused of.
So do we need a report
Well,
from whom?
my lord, it is my lord succeeded, na?
Succeeded.
It is a trial case is over, Your
Trial
Lord.
court record?
He has been
Mile.
convicted.
Huh?
The accused is convicted.
Okay.
Judgment has been made.
Accused is, now what will be the solution? Accused is convicted.
Hmm.
From whom should I get a report?
Well, a record may in the my lord trial
Trial
court.
court record.
Trial court.
Yes, also. And
Well-
mainly the important thing is that while making the judgment, there is no direction has been made in regards to
We'll
the
call for
property.
scan copies, that
Yes.
better.
My lord,
So
can-
the scan copies of the trial court records along with there was no direction in the judgment, okay. So why didn't you file a petition before?
We have filed, it has been rejected, Your Lord.
Okay. Right, call for the scan copies of the trial court records along with the scan copies of the entire case diary. List on. 9 September.
I said. Others.
Met please. Revision against conviction, Lordship.
Mm.
Enact. So I was convicted under section 138 enact.
Concurrent judgments.
Concurrent judgment, Lordship. But Lordship will find I have enacted the complaint.
Have
There
you
is no
deposited
mention.
20%?
Lordship,
Have you deposited 20% anywhere?
no, Lordship,
No.
no, because it's a matter of 2000.
Are you asking for stay? Then we will ask.
Yes,
20%
I am
deposit.
asking for stay, Lordship.
Then we'll ask for 20% deposit.
There is one judgment, Lordship, of Supreme Court and
Waiver.
retrospective effect, because it was matter of 2016, case was filed in the amendment has come in the year with 2000.
No, no.
Lordship,
the
I'll
judgment.
leave it to Lordship.
So we'll ask for 20% deposit
Right.
and we can stay the matter.
Lordship,
If you asking for stay.
yes,
All right, a PP,
my lord,
we can ask for a 20% deposit and they can be, matter can be stayed.
my lord.
Lordship,
Then wait a minute.
For learned counsel, Mr.
Jadal,
Z along for the
petitioner.
petitioner. Ashish Pal,
Lordship,
who is the petitioner?
no, Sukumal Dutta.
Sukamal Dutta, who has filed this application under section 442, read with section 528 of the BNWS 2023, challenging the judgment and order dated 4/7/2025 passed by the learned additional session judge number 3 Kachar, Silchar, in connection with criminal appeal number 13/2021 arising out of NI case number 162/2015, dismissing the criminal appeal referred by the petitioner and upholding the judgment and order dated 23/4/2021 passed by the learned CJM Kachar, Silchar, convicting the petitioner under section 138 of the NI Act and sentencing him to undergo SI for 6 months and to pay a compensation of rupees 3,90,000 with default stipulation. Full stop. The petitioner has also prayed for stay of the operation of the conviction and sentence there was no modification, straight away dismissed, no?
Yes.
While order dated 23/4/2021 in NI case number, what is the 160 of 2015? Full stop. Where is the ground, in which paragraph?
Lordship,
Ground,
grounds, Lordship,
in which
you
paragraph?
find at page 8, 9, 10.
It is contended that the judgment and order was passed in a mechanical manner. causing serious miscarriage of justice without scrutinizing the evidence in its proper perspective. It is contended that the check was issued against debt stroke liability that the prosecution has failed to prove that the check was issued against debt stroke liability. And the petitioner has a good case against the impugned order, full stop. Heard Mr. B. Sharma, learned.
State is not a party.
State is not.
Sorry, another
Oh,
matter.
State is not a party.
No.
I've considered the submissions at the bar. No, at the bar, no. I've considered the submissions on behalf of the petitioner. It appears that the operation of the impugned judgment and order can be stayed under the condition that the petitioner deposits 20% of the compensation amount, full stop. You have paid for bail or anything?
No, suspension
are
of
bail-
sentence.
police-
And yes, Lordship, we may be allowed to, I may be allowed to remain on previous bail because I am still on bail.
Where is your prayer?
Page 12, Lordship will find. Page 13, to remain on previous bail.
The operation of the impugned judgment and order dated 23/4/2025 passed by the learned conviction sentence the operation of the impugned conviction and sentence by judgment and order dated 23/4/2021 passed by the learned CJM Kachar Silchar in NI case number 162 of 2015 is stayed till the next date of listing under the condition that the petitioner deposits till the next date of listing. Until further order, till the next date of listing, until further order, under the condition that the petitioner deposits 20% of the compensation amount before that court.
Lordship, trial court.
Before the trial court. Issue notice to the respondent, returnable within 4 weeks. List accordingly.
Lordship may call for the LCR also. LCR.
Oh, yes. Also call for the LCR of the trial court record as well as the record of title appeal of appeal number.
NI case number, Lordship 162.
And criminal appeal number
Appeal number, Lordship 13 of 21.
from the respective courts.
Deeply obliged, deeply obliged.
Item number 5.
May it please your lordship, this is a new matter, this is a criminal revision petition, lordship, the impugned order is page number lordship 6 for maintenance lordship. The trial court grant relevant portion is lordship.
Family court.
Lordship.
Family court, Borbetta.
Borpeta lordship. So kindly notice may be issued lordship.
Yes.
And after receipt the trial court, my interim order may be considered lordship.
And Miss A. Begum, learned counsel for the petitioner. Naam nalagi likhi dile. Challenging the judgment, petitioner as challenging the judgment and order dated. 16/7/2025.
Lordship.
16/7/2025 passed by the Principal Learned Principal Judge Family Court Borpeta in connection with
FC criminal.
FC criminal case number 265/2022. Issue notice to the respondent, returnable within 4 weeks. As per usual process,
Lordship.
as per usual process, returnable within 4 weeks. Call for the trial call for a trial court record. The prayer for interim the prayer for any interim order shall be may be considered on receipt of the trial court records.
Much.
List accordingly.
And I.
The appeal against conviction in an act. The petitioner was convicted by the London Trial Court 9/7/2025 for payment of 15,000 lodgings. Accordingly, the petitioner filed a criminal appeal before the London First Appellate Court. It is the additional session number 1 of the Kamrup Metro. The London system, the wide order dated 14/8/2025 lodgings. That is the annexure B, page number 40. He declined to admit the appeal. That is the annexure B, lordship, page number 40. He declined to admit the appeal with the observation that he is not satisfied with the grounds of appeal. To satisfy himself that it is a matter of rights, lordship. We have cited to judgment, lordships. Page number 40, lordships. This is the order of the London First Appellate Court, lordship. Made it the
You
41.
want to proceed or you want to issue notice?
Issue notice, lordship.
Issue notice.
Issue
Then
notice.
we'll issue notice.
Issue notice, lordship. And I'm praying for also a stay of the operation, lordships, for suspension of the sentence, lordship.
Then you have to deposit the fine amount 20%.
Yes.
In case of waiver, then you will have to.
Yes, the first appeal, because he declined to admit the appeal, lordship. When there is a statutory appeal, lordship, the kindly proceed his observation, lordship. The observation.
No,
is the-
CC. If you want to proceed, then you proceed.
Yes, sir.
We will finish it off.
But
Allow or we'll dismiss. But if you want to issue notice, then you deposit the
yes,
amount and
sir.
we'll issue notice.
20%.
Okay?
Yeah.
ये तो आगो तो 20% लिखना है। Repeat. IAS. What is this IA for?
Apply for suspension of the sentence.
The petitioner Ujjal Deep Gogoi is aggrieved by the judgment and order dated 9/5/2025 passed by the learned.
9/7.
9/7. Okay. 9/7/2025 passed by the learned special judicial magistrate Kamrup M in case number NI 7072 of 2023 convicting and sentencing the applicant
Operative part, page number 36. Operative part.
under section 138 of the NI Act to pay a fine of rupees 3,15,000 with default stipulation and to undergo simple imprisonment for a period of 1 month. First of the petitioner then preferred an appeal before the
Learned session just Kamrup Metro.
learned session judge Kamrup Metro, which was not admitted. It is submitted that the appeal was not admitted on frivolous grounds. Full stop. The petitioner is prejudiced as his appeal has not been admitted and he is and he has submitted that there is every possibility that his appeal will succeed. Full stop. However, as he was debarred from referring an appeal, . নালাগে কাটি দিওঁ। The petitioner has also prayed to stay the impugned judgment and order dated 9/7/2025. Heard Mr. MP Uswami Lanet, additional PP Assam for respondent number 1. Full stop. The learned PP, additional PP has accepted notice on behalf of respondent number 1. And thus no further notice is required to be issued. Stop. Sufficient copies to be furnished during the course of the day. Stop. Considering the submissions on behalf of the petitioner, it appears that further that the operation of the impugned conviction and sentence may be suspended, thereby the operation of the conviction and sentence by the impugned judgment and order dated 9/7/2025 in connection with NI case number 7072/2023 is stayed until further orders, subject to the condition that the petitioner deposits 20% of the fine. It is 20%, no?
Yes.
20% of the fine amount before the learned trial court, i.e. special judge, no?
No, special mistake.
Special Judicial Magistrate Kamrup Metro. Ito agoto likhi dibasan within 2 months is given, no time?
2 months.
Within 2 months from today. Agoto likhi diba de within 2 months from today. Ito in terms of the until further orders ase no, in terms of the above until further orders question, in terms of the above observation, this I stands disposed of. It would likha issue notice to the, you want to remain on previous bail?
Yes, sir.
You have given the prayer
Yes, sir.
in that file.
In the trial, I was only allowed to go on the previous bail. Subsequently, the appeal was without admission. The appeal was dismissed. The appeal was without admission. The appeal was already dismissed.
Where is your prayer for previous bail? In I,
I accept.
I to likhi your petition is allowed to go on previous bail. Agoto likhila no previous bail. Agoto dise agoto likhi your previous bail. Ito to likhi your previous bail. Last of all, petitioner is allowed to remain on previous bail. As prayed for, the petitioner is allowed to remain on previous bail. Main case to push. Main case to likha, petitioner, learned counsel for the petitioner is present. Learned additional PP, Mr. MP Uswami is present and has accepted notice on behalf of respondent number 1. Full stop. No subsequent notices, no further notice is required to be issued. Stop. Sufficient copies to be made during the course of the day. Issue notice to the respondent number 2 to, as per usual process, returnable within 4 weeks. Call for the call for the original records of criminal appeal number 75/2025 and NI case number 7072 of 2023 from the respective courts. List accordingly. Item 7. Returnable within 4 weeks. Likhila, no? Likhila.
May please lordship, the criminal petition against the NBW lordships. The lordship, the NBW against the issue lordship 19/11/2022. In the meantime, he is in judicial custody. The another case lordship. The recall on 19/11/2022, he is in judicial custody in another case, shown arrest case. In the meantime, the NBW issue against him. Lord.
Oh, that is why warrant could not be executed.
Yes.
Where is the
Order 32 lordship. Accused MD Romazali is absent without any steps issued NBW against the accused. MD Romazali.
1911, 2022.
Lordship, NBW against him, Lordship, the,
Huh?
yes, Lordship.
Yes, no, sir.
এইটা আছে order, মরিয়া order, যেমন আছে। Recall the order dated 1911 and subsequent dates, I faced the trial. It was 38 days. Lordship, the page 38, Lordship, the reflects the Zagirat PS case, PS case number, Lordship, is in custody, judicial custody. 38, annexure 5. I faced
38. FIR.
Lordship, 38 case.
37 will be the latest order because 38 order of 2022. It's page 38. Go to it.
কত কেস তেতে
It will be.
যেটু তেতে দিদি আছে
Oh, it is 2619.
কাস্টডি আছে
This is 2619. It will 2619. দুইটা একই কেস
এইটো রিফ্লেক্ট কৰিছে না মৰিগাঁও কেছটো আছে
তাকে মিলি কৈছে
এইটো আছে কাস্টডি আছে
গম পাইছো এইটো কেছ এইটো হ'ল অৰিজিনেল খেলি মেলি হ'ব ইমপ্লিমেণ্ট অৰ্ডাৰটো কোনটো
এইটো 19
19 কেনেকুৱা ইমপ্লিমেণ্ট
accept কৰিছো কাৰণ বনাব পৰা নাই
সেইটো হ'ল 22 অৰ্ডাৰ 2619 তাৰপিছত এইবোৰ অৰ্ডাৰ তাকেতো 22 অৰ্ডাৰ 2619 37 হয় 2619 এইটো 26 অৰ্ডাৰ এইটোহে মেইন অৰ্ডাৰ
এটা ডিফাৰেন্ট হৈ আছে এটা
সাবসিকুৱেন্ট
মেইন অৰ্ডাৰ সেইটো এবার ওখানে সাবসেট হয় নাই তো ওসবে সাবসেট তো ফেলে হয় নাই
You are shown as you are in custody.
yes on that Test 38 lordship the reflect the case numbers.
So when
Zagirat
that
case.
NBWA was issued, have you
Issued,
applied
Lordship.
for bail there in the lower court? Have you applied
Lordship.
for bail in the lower court?
Bail bond is accepted, lordship, the page 31 lordship. Bail bond is accepted, but he in judicial custody in another case. Shown arrest case.
So what is wrong in this order? To set aside and quash, what is,
There's the set aside the order, lordship, I face the trial, lordship, recall and subsequent order.
there has to be some error.
Yes, lordship.
there is no error.
Hmm?
He can also apply for bail there, but
He can
whether he has
apply for
approached that approach নাই কৰা নেকি because already you are in jail
The apprehension,
already in
lordship,
custody my lord
only for apprehension, lordship. So set aside, lordship, recall the order at night.
let him appear
Let the
or
trial-
honorable court will
You can
decide
direct an order where you, he is already in custody.
already in custody so what nothing only
He
he
can
can
pray for bail.
yes he can pay for bail there
I'll give you direction and dispose this matter of.
And recall the order, lordship. I approach the trial.
NBW, I cannot recall. Their lower court will recall. NBW.
Lordship, direction may be,
Hmm?
direction may be given, Lordship. Reference.
He can appear.
Direction to consider a bail.
Lordship.
It will be like granting bail then. What will be the, any suggestion from your? From your side?
He can appear in learned trial court
Will
will decide as
consider
per
it.
law.
I have no objection if he is released on bail. What will be the better way? Any suggestion, better solution?
Otherwise, because already in custody, madam,
Yes,
he
yes.
can then,
Hmm.
at least he can pray for a regular bail there, madam. Otherwise,
There has to be some error, no?
because there is no error assessment for, so, and trial court will decide as per law. With all the facts, he can file a bail petition, madam. Setting all the facts. No, it is good.
They were released on bail.
Yes, they were released on bail. Your lordship will find page
211,
page 23. Page 23. Lordship. Page 23, his bail accepted and released on bail. Thereafter again absent.
Because he is in another case,
And,
that is
in
why he
judicial
could not
custody.
be released.
Yes.
That's a case, I think, the individual first is like this, sir. Okay.
If he files there, I think, madam,
Release
court.
order also has been issued.
Yes. Court,
Release order has also been issued.
Yes, no.
release order, madam.
Accepted.
Or-
Bail bond.
Yes, that is 23, madam.
23, no, I don't. 1511.
This can be set aside because he is in jail,
Jail.
and
No.
then as he is in jail,
Or
He-
lordship may suspend until then he can appear. Till his appearance, it can be suspended.
no, but he is still in jail.
Yes, it can be suspended till his appearance. Then, most probably,
Because the order that's suspended.
Production warrant has to be issued.
Yes, yes.
He won't be able to appear now.
or they will be able to appear.
So production warrant has to be issued by the
Issued
court.
by that court, madam.
Recall the production, lordship, recall the NBW and subsequent order, I faced the trial, I filed a petition for
Recall-
bail.
You are asking me to recall the NBW?
Yes, yes.
No, no. Recall, the court will recall who has issued the NBW. I can give a direction,
Yes.
482, can I recall the
No, sir.
NBW under 482?
Recall, madam. Only suspension can be made, otherwise your lordship has to see.
I am in judicial custody,
Yeah.
recall. At that time.
This is 482, na?
Sorry.
Yes.
You've given a prayer for recalling the NBW.
Yes, sir.
Five 528.
No, it is 528, no. Yes, my lord, it will be my, lordship may suspend it for time being, my, he can make a
If it
prayer for,
feels like I do.
yes, he can make a prayer for recalling there, my lord. Most probably it will be recalled because on all the facts and circumstances.
He's still in jail in connection with the other case.
Correct.
What is the other case?
Morigaon, Zagirot, 300 to /2022, page 38. First para, last slide.
Okay. Our Learned Counsel, Mr. M. Hamid.
N. Ahmed.
N. Ahmed for the petitioner. Ramesh Ali, who has filed this application under section 528 of the BNWS 2023 with prayer for setting aside and quashing the order dated 19/11/2022 and subsequent orders passed by the learned SGGM within bracket S bracket close number 1 Kamrup Metro Guwahati issuing NBWA against him in connection with PRC case number 1246/2019 arising out of so and so PS case under so and so sections. The allegation against the petitioner is that he switched ATM card with the informant and withdrew money from the informant's account. Full stop. Through the through the informant's ATM, fraudulently through the informant's ATM card. Full stop. It is called ATM card only, no?
Yes, sir.
Debit card.
Debit.
ATM card stroke debit card. Full stop.
In this case, when page 38, my lord, a prayer was made for production of Ramesh Ali and Mintu Gorman before the my lord, additional CGM Morigaon. But that was rejected as saying that, my lord, that only Mintu Rahman is facing trial in this case, whereas other accused in this case is named as Ramesh Ali. So I have prayed for both Ramesh and Mintu, but only Mintu is granted. What order is this, my lord? I do not understand, my lord. Right.
Page 38.
Page 38, last page, my lord.
ওটাই এরেস্টটা আছে লাইক ক্যান্সেল করিল
ওটা already-
মরিগাঁও জেলাত আছে
ও মৰিগাঁও জিলাতে আছিল তো। Perhaps he is in the Morigao jail at that time. That is.
It is not required.
Yes. Lordship,
He has observed something from the records
Lordship,
and the two in connection with Morrigan.
Morigao. Lordship, dispose of.
It is submitted on behalf of the petitioner that the petitioner. It is submitted on behalf of the petitioner. The third Mr. MP Goswami Lane edition 50 Assam. It is submitted on behalf of the petitioner that the petitioner was enlarged on bail of rupees 20,000 with a suitable surety of like amount. Full stop. However, as the petitioner was behind bars in connection with another case, despite submitting bail bond and issuance of release order, another case number to litigation, another case being case number what?
জাগিরোড পিয়াস কেস নাম্বার 302/2022
Despite submission of bail, despite acceptance of bail bonds and issuance of release order, the petitioner could not be. The petitioner had to stay behind bars, as he was not granted bail in connection with the other case pending against him. Full stop. Thereafter, during the course of the proceeding, erroneously, by order dated 19/11/2022, NBWA was issued against the petitioner. Instead of issuing production warrant against him. All right.
yes
You have mentioned in the
Yes, sir.
petition, which paragraph?
yes sir 19/11/2022
No, which paragraph?
the
No. Which paragraph of your petition?
lordship the prayer portion is there lordship
Not mentioned.
prayer portion is mentioned lordship prayer is the set aside the order dated
No. See, I'm asking whether you have mentioned that instead of issuing production warrant, NBWA has been issued against him.
yes sir
You have mentioned which paragraph?
paragraph 6 lordship
No, you have not mentioned that in paragraph 6. No, full stop.
Paragraph 7, ma'am.
Paragraph 7?
plus 7%, 7 also
He was unable to appear in trial due to his own arrested in.
paragraph 7
It is submitted that he was unable to appear before the trial court, before the court of the SCM 1 Kamut M, as he was shown as arrested in connection with Jagiro PS case number 302/2022 under section 420/379 IPC. owing to the detention, the petitioner is being harassed and the order dated 19/11/2022 and the subsequent orders are liable to be set aside and quashed. I have considered the submissions at the bar with circumspection. It is submitted on behalf of the petitioner that he is willing to cooperate with the trial. So considering all aspects, the petitioner is hereby directed to approach the court of the SDGM-1 and apply for bail, which may be considered by the court in accordance with law. The NBWA issued against the petitioner is kept in abeyance till his appearance before the till then the NBWA issued against the petitioner is kept in abeyance. Okay. I think this is a wrong order also can be set aside, but that ground is not given.
Yeah.
That issue instead of issuing production on that ground is not given.
Granted. Next date is 10/10. Next
10/10.
date.
Okay. In terms of the above observation, this petition stands disposed of.
PRC case number, PRC case number 2619/2022.
Which one?
PRC case this.
I have.
WWC.
Well, in this case, my lord, petitioner, my lord, has completed my lord LLB final year lordship. And the my lord informant is also my lord LLB students. They entered into marriage, my lord, while they are starting my lord LLB post lordship. Now, on 14th September 2024, my lord, she was missing from the rented room lordship. Then after 4 days, my lord, missing information was my lord submitted my lord by the present petitioner husband lordship. Thereafter, my lord, she was called for by the IO lordship, and in reply that missing information, my lord, she lost a bag, my lord, bag and my lord omnibus allegation lordship. Many allegations, my lord, without now none of the allegations establishes any criminal, my lord, offense lordship. Now investigation was done, my lord, kindly see page 98, charge sheet lordship. The petition was granted bail lordship, PRH bail lordship, page 98 lordship, charge sheet, operative portion lordship. Lordship, second para, during married lordship. During the investigation, the place of occurrence was visited and its sketch map was drawn. No witness was found against Syed Akib Ahmed at the place of occurrence. The victim was questioned and her statement was recorded in connection with the case, and when it was intended to get her health examined by doctor, she refused for medical examination. Notice under section 35(3) BNSS was issued to Syed Akib Ahmed, and he appeared at the police station with an order of interim PRH bail passed by the Honorable High Court. He was questioned in connection with the case and was released on bail as per order of the Honorable High Court. His father, Abdul Khalik, took him on bail. The bail bond has been tagged with the case diary since a well-established case of committing offense under section so-and-so has been found. I have submitted his charge sheet to the Honorable Court in consultation with the officer in charge. My lord, no witness was found, my lord.
Court closed the evidence of those two witnesses. Subsequently, my lord, the court also closed the evidence of the IO. So two charge sheeted witnesses and the IO was not examined. Subsequently, my lord, after I gave evidence, I tried to inquire about the status of the case, and I found out that the case had been fixed for SD, and these two vital witnesses and the IO had not been examined. So first I filed an application to assist the PP, my lord, 301 application. That application was allowed. Thereafter, my lord, the PP and I in the trial court filed an application under 311 CRPC for calling those two witnesses whose evidence had been closed and the IO, my lord. Now that application was rejected, my lord, by the trial court. So the vital witnesses and the IO have not been examined. Now the court says that the delay is being caused, my lord. But delay in trial, only for the ground of delay in trial, my lord, evidence of witnesses cannot be closed, my lord. So I will kindly show the orders, my lord. The lordship will first come to page number 34, my lord.
30?
34, my lord. May I read the order?
34, no?
34, my lord. Accused person, Abdul Ahad is present. PWs are absent. Bailable warrant of arrest issued against PW, Shafiquddin and Riazul Islam not returned. Learned ABP has prayed to dispense the evidence of PW, Shafiquddin and Riazul Hussain. Considering the submission made by learned APP and the fact that bailable warrant has not been issued against PW, Shafiquddin and Riazul Hussain on 2 dates, the evidence of PW, Shafiquddin and Riazul Hussain are dispensed with. Issue summons to the IO. Now, my lord will kindly next come to page 42, my lord. 42 is.
The impugned order.
No, not the impugned order, my lord.
Page?
Next is, my lord, page 42 in the additional affidavit, my lord.
Okay.
42, my lord. Accused Abdul Ahad is present. No PW is present. Peruse the case record. On perusal of the case record, it is seen that the case is pending at the evidence for a long time. The record further reveals that on the previous date, so and so, the prosecution was given a last opportunity to bring its witness. However, no witness are present today. Now, right to speedy trial is one of the constitutional rights given to an accused, and violation of it is an infringement of his fundamental rights. The prosecution, despite being given ample opportunities, has failed to procure the attendance of its witnesses. Considering the above discussion, prosecution evidence is closed. Now, my lord will kindly come to page 43.
This is the impugned order, no?
No, my lord. These are the evidence closing orders, my lord. Then page 43, my lord, this is my prayer to assist the PP, my lord. Because only then I found out that this evidence has been closed. Accused person so and so is present. This is the informant has filed a petition by number praying before the learned court to allow learned counsel she so and so to assist the learned PP. The learned APP has no objection. Prayer is allowed under section 301 CRPC. So here, my lord, assisting prayer is allowed. Now, your lordship will again come to page 35. This is the impugned order, my lord.
Okay.
35.
Mm.
May I read, my lord? Accused person is present. Heard both sides on petition number so and so filed by the prosecution under 311 CRPC. The learned APP on behalf of the state has stated that the witnesses that are mentioned in the petition are very important as they will help in proper adjudication of the case. The defense strongly objected the petition by stating that the said witnesses were dispensed at the prayer of the prosecution side. So far as the IO is concerned, the prosecution was given the last opportunity. The evidence of IO was closed only because prosecution could not produce him on given opportunity. Peruse the CR. On perusal of the CR, it appears that the court, wide order dated 13/2/23, dispensed the evidence of witnesses, namely Shafiquddin and Riazul Hussain, only on the prayer of learned APP, as both summons was duly served on both the witnesses, but they did not turn up. So far as the IO is concerned, the prosecution was given the last opportunity, but the prosecution failed. Thus, for all the witnesses, the prosecution got ample opportunity, but could not produce the witnesses. The petition under section 311 was filed at the stage of argument and prosecution witnesses was closed by order dated so and so. The court fails to understand why the prosecution took 1.5 years to file the evidence. There should be to file the petition, file the evidence. I also take note of the case of Zahira Habibullah Sheikh reported in so and so, whereby Honorable Supreme Court has clearly stated that the power vested under 311 CRPC should not be allowed to fill up lacuna at the later stage. Here, the evidence of the witnesses were closed only at the instance of prosecution side. Allowing the petition at this stage will only help the prosecution to fulfill the lacuna, fill up the lacuna, and will prejudice the accused person. Under the said circumstances, the petition stands rejected. Now, the first reason which the court has said that why this petition was filed at a belated stage, my lord, it was because I only came at that stage, my lord, to assist the learned PP, my lord. So I did not know because I gave my evidence and I went away. It was only subsequently that I found out that these vital witnesses and the IO had been closed, my lord, their evidence. So I came. So there is this observation that why this prosecution came late, my lord, has no basis. And this judgment, my lord, this is the strangest part, my lord. This judgment which has been like, this judgment does not say this, my lord. This judgment says, your lordship knows, contrary, my lord, that this plea of filling up
Yes.
of loophole and lacuna cannot be taken if evidence is
So
there.
it's allowed to abuse evidence.
Yes, my lord, that was the finding there. I don't know why the learned trial court has given this finding. Now, my lord, these two witnesses, they know about the case. And IO, my lord, if the IO is not examined, the defense will come up and take the plea, because if there are contradictions, then because of the absence of the IO, contradictions could not be proved, and this will be fatal to the prosecution's case. Let these witnesses be examined, my lord. Whatever is there, they will get ample opportunity to cross-examine. Just because the trial has been prolonged for a while, that does not mean that available
Where are grounds in the petition?
petition, my lord, that petition your lordship will find in the second additional affidavit, my lord.
No,
That-
no, not that petition.
311 petition, my lord.
Yeah, no,
Oh,
not.
in this
311.
petition, my lord. Oh, sorry, my lord.
Those witnesses were not examined at all.
Not examined at all, my lord. Ground starts at page 7, my lord.
Okay.
Ground number C onwards, my lord. And regarding these two witnesses, ground number E and ground number F, my lord.
This case is under which section?
My lord, 420, my lord.
Huh?
420, my lord.
420.
420, my lord.
Like my is he?
Relating transaction of money, how much?
My lord, initially, this term 1,80,000 rupees were given. What facts of the case was that the petitioner before your lordship, this petitioner was married to a person, my lord. Subsequently, there was some dispute between the two husband and wife, and the petitioner filed MR cases and CR cases against the husband. Now, the accused of this case, my lord, subsequently some reconciliation took place, and the accused of this case, he agreed to act as a mediator, my lord. And the husband paid this 1,80,000 rupees to the mediator to pay it to the wife, my lord. And this person did not pay the money, he kept the money, my lord. So husband paid the money and wife withdrew the cases on this assurance that she will get the money. She withdrew the case, and this person, my lord, he misappropriated the money.
Yes.
Apparently, my lord, the petition filed by the prosecution side, my lord. For calling the IO.
Mm.
These are, and the law which has been cited, that law has been wrongly cited by the court. At least the court should have cited correct law, my lord. Let these witnesses be examined, because now as a victim, I don't even want to say stay, because if I seek stay, my lord, tomorrow they will come, then they will keep on taking time, and case will get further prolonged.
Okay, we'll
Yes.
give a direction to examine
ma'am.
the witnesses.
Not
Third learned counsel, Mr. S. Nawaz for the petitioner. Afroza, this is 420 case, no?
Yes, my lord.
Afroza Begum, who has filed this application under section 520 of the BNWS 2023, challenging the order dated 3/6/2025 passed by the learned additional chief judicial magistrate Hojai, in connection with GR case number 1774/2016, whereby the court rejected the petitioner's application under section 311 CRPC.
Prosecution's petition.
Oh, huh?
Prosecution's petition,
Oh, okay, okay. Not petitioners.
not petition.
not
But you have
petitioners, my
written
lord.
petitioner's petition.
The petitioner,
The petitioner was assisting the PP, so it was on the head of the PP.
Where the court had rejected an application under section 311 CRPC, praying to recall and examine prosecution witnesses. They were examined earlier,
No, not examined.
not examined.
Not examined, directly clear.
It is submitted on behalf of the petitioner that the witnesses, what are the names?
Sofiquddin, Riazul Hussain, and the IO.
Sofiquddin and Yazul Hussain are eyewitnesses, and their evidence and truth will only prevail if their evidence is recorded. Full stop. The petitioner is highly prejudiced by the order, as the learned trial court has rejected the application to recall the witnesses, and Sofiquddin, Riazuddin, as well as the IO. Full stop. The evidence of the IO is crucial for the case, as contradictions could only be
Contradictions, if any, can only be.
Contradictions, if any, can only be affirmed or dismissed on the cross-examination of the IO vis-a-vis the prosecution witnesses. Had Mr. MP Goswami learned additional CP, Assam. The learned additional chief judicial magistrate by order dated 3/6/2025 has rejected the petition under section 311 CRPC as there was a delay, there was a procrastination of trial by the prosecution.
By the prosecution.
To stop the prosecution even filed the petition, evidence of petition after 1.5 years.
Sorry, my lord, I could not understand. my lord, the
That
question.
page number 36,
36.
just the paragraph before the highlighted part.
Oh, my lord, that should be petition, my lord. That's wrongly written as evidence.
It was observed that the prosecution filed the petition as after a span of 1.5 years. Which had protracted the case. Section 311 CRPC reads, hello, Bharadwaj. The case was fixed for
Argument, my lord.
argument.
Argument.
This case was fixed for argument, and at that stage, the petition under section 311 CRPC was filed. The instant case was fixed for argument. The impugned order is marked as annexure 5 of the petition. Full stop. Prior to this order,
Page 34, my lord.
while order dated 3/2/2023.
13, my lord, 13 to.
Oh, 13/2/2023, yes, 13/2. It was observed by the court, trial court, that the additional PP. No, the order, by order, the order, the order dated 13/2/2023 reflects that the prosecution made a prayer to dispense with the evidence of PW, Sofikuddin and Riazuddin. And on submission of the prosecution, the evidence of PW, Sofikuddin and Riazuddin was dispensed with.
Then, my lord, page 42. In the additional access.
This order is marked as annexure 4 of the petition, full stop. Page 42.
42, my lord. IO's evidence is closed.
Thereafter, while order dated 9/10/2023. Prosecution evidence was closed. We didn't get annexure 6 with it yet. To sub later on 14/5/2025, when the petitioner learned that this case was fixed. On that day, she learned, no?
Yes, my lord. So prior to that, she learned, and on that day, she appeared, my lord.
14/5 to 30. when the petitioner learned that this case was fixed for argument, the petitioner fixed for argument.
He's fixed for argument, it's there in the order also.
This case was fixed for argument. The petitioner filed a petition under section 301 CRPC, and this petition was allowed, enabling the petitioner to assist the prosecution by order dated 14/5/2025 within bracket annexure 7.
Then my lord, page 35 is the impugn note.
Huh?
35 is the impugn.
No, that I have noted. It is apparent that on the prayer of the prosecution, the prosecution the evidence of the aforementioned above named witnesses has been dispensed with, and the prosecution evidence was closed, precluding the prosecution evidence was closed without examining the IO as a witness. Full stop. For the interest of justice, it appears that an opportunity may be afforded to the informant. She is the informant.
He's the informant.
To the informant, the opportunity may be afforded to the prosecution, as well as the informant to honor to place their litigant, to place their case although there was a delay by the prosecution, comma, an opportunity is afforded to the petitioner according to the petitioner number. I'll add later.
These
whatever
judgments
feel
I have, my lord,
appropriate.
Zahira Habibullah, that has been wrongly cited, my lord, if required.
It's not required. In view of the foregoing discussions, the impugned order dated, what is the impugned order?
3/6, my lord.
Is set aside.
3/6/2025.
The trial court is directed to examine the witnesses naam kita likhi diba, including the IO for the ends of justice. In terms of the above observation, this petition stands disposed of.
I'm deeply aware.
No, I'll give you some time. I'll give the trial court is the
Case is otherwise fixed on 29th, my lord. Lordship may fix a time within which they may examine.
time frame is not required. Every endeavor should be made by the trial court to examine the witnesses and dispose of the case within expeditiously. Expeditious.
Deeply aware.
এইটো মাতি দিয়া এইটো লৈ লওঁ শুনি লওঁ মাতিছিলা ন কোন আছে আহা নাই নেকি?
Last time also none. Lordship.
আহি পেলাই অৰ্ডাৰটো পাছ কৰিম আহিছে লিখা লিখা no representation on behalf of the petitioner on call. First of earlier on 21/7/2025 the petitioner was also absent and was not the petitioner was not represented. It appears that the petitioner is not interested to proceed further. Mr. MP Usmai is present. Learned addition PP, Mr. MP Usmai is present for the state. You are there?
Yes.
You are there, okay.
Yes.
List this matter after, list this matter after 2 weeks on failure or appearance of any of the parties. Adverse order may be passed. This case may be disposed of on merits. Adverse order may be passed. Edo heady niki? A revision petition niki?
No, it is not revision, madam. It may not be required, madam. Last.
Merits na
Yeah.
Adverse orders may be passed.
Adverse.
Or you want me to dismiss it?
No, no, say.
Madam.
Hmm?
Podcast madam, YouTube pilot, he sometime he
Okay,
comes.
okay, okay.
Abhishek Kaur madam. He is from Madhya Pradesh, Indore madam. So he
And,
might,
you know, it has come up.
yes, madam.
Something against the government.
Yes, madam. Not government madam. In Mayang, he said that there is a village in Assam. Where my lord, till night time, my lord, that men become women, and that's where my
Oh,
lord.
that I don't know.
Yes, your lordship also. Bail already got my lord, bail in time was there. Then now I have come, madam, it is a case, madam. Ultimately, there is no chance of it. And this person from Indore, madam, Madhya Pradesh, he is to come. It is nothing but abuse of law, madam, because nothing. Whatever he has taken, he reiterated the things which is already in public domain, madam. Already it is public domain. With already I take your lordships to that page. Your lordship, and he also sought apology also, my lord. Your lordship kindly see, my lord, yes, page my lord, 154. 154, my lord, it start 154.
You are against, you have come against the FI.
I have come against the FIR, my FIR question. Your lordship kindly see page 150 it start. It is a page 150. It is WhatsApp communication between the petitioner and the podcaster.
Okay.
First of all, my lord, I take to your lordships to that. Yes. That it was in one page 70. Yes. Page 7, my lord, just, I'm sorry, page 73, my lord. Page 70. What he has stated in an interview to the, my lord, that in YouTube, my lord, he was just replying to the some questions.
Page 73.
Yes, page 73. 56.46, your lordship. Page 73.
Okay, 56.46.
Yes. No. Abhishek, myself, my lord. So there are practices happening which have been happening for a long time, and maybe people won't believe them. But all these things are happening. For example, if you go to Assam, there is a place where they say the girls of that village have been powerful spiritual abilities, that they have the power to. As a human, it is not false, my lord. He has retaliated what's there in the public domain. It was in the Google file. He simply retaliated that segment. Then your lordship will find information technology, section 67. Bottom.
where publisher transmitter causes to be published, transmitted in electronic any material which is CBS or appeals to the, that is also not applicable in that case, madam. Then Assam Witch Hunting Act, madam. Next page, your loss. Witch hunting, madam, actually some victim, your loss will pay the definition action video. Definition of victim, madam, it is personal, madam. If personally it is somebody's sentiment is hurt or some, then only madam this act comes. It says, madam, section 4 of the Witch Hunting Act. I am just giving the act, madam. Though I have given type copy, madam, your lordship.
It's okay.
Yes, madam.
Okay, it's not required actually. I have gone to this.
So no person shall identify, call,
It's okay.
state. So my these are the things whether any of the integrate whether attacked or not, madam. So my humble submission, but it is nothing but only abuse of law, madam. These things further proceeding goes on, madam. Nothing at all. Nothing will come out, madam. And only
So there was a submission before this court earlier.
courts for my lordship will find.
That matter was not stayed by this court.
Yes,
There was a submission earlier,
yes.
but the matter was not stayed by this
No,
court.
ultimately it was decided by interim was given by Honorable Justice Bedul Kolita.
Where?
Interim your lordship on page 176.
In this matter,
Yes.
interim bail.
No, not in interim that we came here for a pre-arrest bail, madam. Antecedent bail,
3 years bail.
pre-arrest bail.
No, but here it was before Justice
No.
Manish Chaudhary, but no interim.
No,
bail
no,
was
no.
given.
In this case, we the first time we come for quashing of the FIR. Oh, that was adjournment, madam, because time was not there, madam.
Okay.
Time was short, so that could not be taken up, madam.
All right.
So this is, I think, madam, your lordship kindly see.
You are referring to some
Yes,
judgment here.
your lordship kindly see referring, madam, first, your lordship kindly see 24 live law. Paragraph, your lordship will find 26.
Yes.
Your lordship kindly see, this is yes. From a bare reading of a language of section 153 IPC, idea 153 IPC, madam, it is clear that in order to constitute such offense, the prosecution must come out with a cause with a case that was spoken or written attributed to the accused, created enmity or bad blood between the different groups on the ground of religion, race, place of birth, residence, language, etc., or that acts so it is or prejudicial. Then your lordship will find page 29. Sorry, paragraph 32, my lord. Bhojanlal, referring to Bhojanlal. Number 1, your page 32.
That famous paragraph 102.
Yeah. The number 1, my lord, where allegations made in the first information report or the complaint, even if they are taken face value from the integrity, do not claim as a procedural case. Then another other case, my lord, this is the latest 125. Madam, paragraph 15.
Okay.
Paragraph 15, man. The other case, that is a party name is Manchu Mohan Babu. Your lordship, what is one?
No? Yes.
Yes, paragraph 15, your lordship kindly say. 15.
All right.
This court in so and so reasoned that the criminal process cannot be utilized for any oblique purpose or held that while entertaining an application for quashing initial stage, the test to be applied is whether the uncontroverted allegations prima facie establish the offense. This court also concluded that the court should quash those criminal cases where the chances of ultimate conviction are bleak and no useful purpose is like to be served by the continuation of the criminal proceeding, so and so on. So, my these are the things your lordship is having us. I think it is a case, my lord, nothing but a visa process of.
What do you have to say?
Just I lift your lordship, my lord.
My lord, record me call my lord, he is not, he is in bail, my lord, he has no immediate, my lord, in, my lord.
Danger, no imminent danger.
Yes, my lord, yes, my lord, and it is a issue is, my lord, it's a big issue, my lord. So, my lord, he writes, my lord, almost, my lord, it is, my lord, so many things in his write-ups, my lord. No doubt he has made an apology for that, my
Only
lord.
one
But, my
paragraph.
lord, so many things are there, my lord, in his speech, my lord, it's a long speech, my lord.
Where is the
Kindly have a call for the
Yes.
record, my lord.
FIR is page 24. Informant is the policeman, Saiba Khan. Page 24. You also got it.
Yes, yes.
With reference to subject above, I have the honor to report that on Abhishek Kaur, through YouTube channel, so and so, mentioning that in Assam there is a place where girl practice black magic and convert so and so. So this is what by the his conversation. Abhishek Kaur has made derogatory remarks against Assamese women deliberately with the malicious intention of outraging so and so. Where is that?
It is arising of the NI Act mile. NBW was issued against the petitioner mile. Both the petitioner and the informant was issued of Silchar mile. But the complainant somehow file a case over the Guwahati mile. And the petitioner is about 74 years and more than that. He is not regularly appearing before the learned trial court. Henceforth, the NBW has been issued. And I come under that with only that is the next date is 29.
You represent him in the trial court? NI case, you can easily represent him. He does not.
This may be passed on. That may be passed on according to
No,
I'll represent.
why should I pass? Where is your prayer?
That is my lord for I am for quashing the NBWA, my lord.
Oh, you have already filed an affidavit relating to this,
Yes, my lord.
to be represented.
To be represented.
Okay, the last order contains.
Yes,
this.
no, that is there, my lord. But he cannot come from
So
Silchar.
you have given an additional affidavit also.
Yes, no, not file, my lord, because my lord, he is come down from Silchar to here, my lord. He
You
cannot-
have you filed an additional affidavit?
No, my lord.
But last order it.
Last one, that was there, my lord. I communicate to the petitioner, my lord.
Without
but-
that prayer, I cannot pass this order to be represented. You approach the court yourself, the court will definitely allow you to be represented. Under section 205 or 3,
Yeah,
17, now
17.
the new, I do not know.
Yes, 17, my, no.
Now new, I do not know, but that under old CRPC, that is what I am saying. Where's the impugned order? Which page?
Yes, my lord. Page 34, my lord.
Yes, PP. He wants to appear, well, he can appear.
The state is a formal party, no? And that's
Third learner counsel, Mr. BP Sinha, for the petitioner. Sri Guda Sinha and learner additional PP, Mr. MP before me. For the,
for respond number 1, man.
B Sharma, sorry.
Respond number 1.
Learned additional PP, Mr. B Sharma for the respondent number 1. Full stop. The petitioner has filed his application under section 528 of the BNS 528 read with section 438, 442 of the BNSS 2023. With prayer for quashing and setting aside the order of issuance of NBWA issued by the learned, only NBWA. Subdivisional Judicial Magistrate S number 2 Kamrup Metro at Guwahati on 4/5/2024 and subsequent orders.
No, that is the last order. That is the
Okay.
last.
And order dated 28/5/2025 in CR case number 464C/2019 fixing for show cause notice and appearance and report on 29/8/2025. It is submitted that the petitioner is 74 years old and he was unable to attend regularly.
Yes, ma'am.
And this was the reason why the petitioner was unable to be present in the court when the interim orders were passed. It is submitted that the petitioner intentionally did not it is submitted that the petitioner did not intentionally cause the delay and the latches in the trial as he was unable to appear regularly due to his old age. Full stop. The petitioner has to travel 300 kilometers from Silchar to Guwahati as he is a resident of Silchar and this case has been instituted at Guwahati.
Yes, ma'am.
And the case has been brought instituted against him at Guwahati. Full stop. The petitioner is willing to cooperate with the remaining part of the trial. Full stop. I have considered the submissions at the bar with circumspection. I have also scrutinized the copies of the orders of the learned trial court marked as annexure
F, ma'am.
E and F
Yes, E and F.
of the petition. I have taken a pragmatic view to stop as the petitioner is willing to cooperate with the remaining part of the trial. The NBWA issued against the petitioner is kept in abeyance for 30 days within bracket 1 month. Full stop. The petitioner full stop comma D, within which time the petitioner shall appear before the learned trial court and cooperate with the trial. Full stop. Okay. Disposal. In terms of the above observation, this petition stands disposed of.
Item 15.
Yeah, Bill Lordship. Lordship, the matter is, as petition has been filed, my lord, for 528 of Lord TBS and BNSS, my lord, for quashing of the DD case, my lord, which is pending before the learned University first class, my lord, Nalbari, my lord. The case is the petition, the allegation against the petitioner is that they have due to mental and physical harassment and the demand of dowry, they have driven out her, my lord. The original fact is that, my lord, I have stated in paragraph number 2, my lord, Lord of Privacy. Page 3, my lord.
Yes.
That the brief facts leading to the filing of the instant petition in the first part of the year 2023, the petition number 2, that the mother-in-law of the every person, my lord, went to see the daughter of Azimuddin, namely Azida Khatun, the every person, my lord, for her son Mainul Ali, that is petition number 1, my lord. And the girl was liked by both the petition number 1 and 2, and as such, they decided to marry her to the petition number 1. The family members did not allow girl to speak with the petition number 2, and only petition number 1 was allowed to talk in presence of their family. Without thinking too much, the family members solemnized their marriage before the Sadar Qaziyat Rohingya on 15/5/2023, my lord. Both the parties then decided that the social marriage ceremony will be held in the November 2023. A few days after the nikah, the petitioner went to bring the bride Azida Khatun to their home, but the parents of the aggrieved person did not want to send her to the house of the petitioner. However, after consultation, the parents allowed her to go her matrimonial house. After coming to her matrimonial house, the aggrieved girl did not talk to the petitioners, stayed shut inside alone, and would not eat even when called. When there was nobody at home, she talked to herself alone. The petition number 1 and 2 immediately informed the parents of the respondent number 2, that aggrieved person,
about the matter, and only then they revealed that the Azida Khatun and had a mental illness and had been consulting a psychiatrist. Later on, the parents of the Azida Khatun came to the house of the petitioner and took her with them, stating that they would treat her. The petitioner number 1, that is the husband of the aggrieved person, my lord, also went to the hospital with the aggrieved person and her parents, where he came to know that Azida Khatun had been suffering from mental illness for many years and would have to continue taking medicine this way. The parents of the aggrieved person, hiding the truth and with conspirational intention, married the girl to the petitioner number 1. Although the petitioner went to bring the girl back and told them to the petitioner would take responsibility, my lord, for her treatment. The parents, along with her family members, continued confined her and did not allow her to talk or meet petition number 1, that is husband of the petition, aggrieved person. The petition number 1 has continuously trying to bring her back, but the family members of the aggrieved person have not allowed it. On one occasion, the petitioners went along with several respected persons from their village.
Okay.
Lordship, thereafter, my lord, the petitioner number 2, that's the mother of the petitioner, my lord, he has filed a complaint against the petitioner.
Yes, I have read it.
Lordship. And after filing the complaint, my lord, they have filed this case, my lord. And we have in annexer, my lord, 1, my lord, the complaint case is here, my lord. And complaint case has been registered under which is registered and 40 CR case number 40 of 2024.
You want to quash that case against you, DB case?
Lordship, DB case. And I am ready to accept her, my lord, at any cost, my lord. And we'll accept her, my lord. We are trying our best, my lord. Pre-legal notice has been served.
Where is the DB case?
Lordship, page 24, my lord. We have also filed.
Please read.
Lordship. From page 26, Lordship. Sir, the details of the aggrieved woman case is that the victim is a simple, innocent, helpless, unfortunate, and poor woman. On the other hand, the opposite parties are cruel and quarrelsome people from the same family. On 15/5/2023, the aggrieved had solemnized social marriage with opposite party number 1. After the marriage, the aggrieved went to her husband's home and lived with her husband. However, a few days after the marriage, the aggrieved husband and his family members started torturing her, demanding rupees 2 lakhs and high quality furniture. The aggrieved husband, opposite party number 1, asked her to bring money and furniture as dowry from her mother's house. The other opposite parties encouraged the aggrieved husband to demand money and jewelry. When the aggrieved refused to bring the money and furniture as demanded by the opposite parties, they continued to torture her. The opposite party number 7 and 8 are the victim's husband, maternal uncle and aunt. They occasionally came to the aggrieved husband's house and instigated the aggrieved husband and family to demand dowry. They also themselves demanded money and furniture as dowry from the aggrieved person, used obscene language and threatened to kill her. The aggrieved husband, influenced by the other opposite parties, abused and assaulted her. On 15/8/2023, the opposite parties assaulted the aggrieved and driven out of the house. The aggrieved called her father, who took her back home. Since that day, the aggrieved had been staying at her parents' house, and the opposite parties have not taken any information. That is, my lord, no FIR has been lodged against the petitioner, my lord. On 10/5/2024, my lord, the aggrieved along with her father and relative went to her matrimonial home, but she was not allowed to enter because she did not bring the demanded rupees 2 lakhs and furniture as dowry. So she returned. The aggrieved tried several times to go to her matrimonial house with her parents and relatives to live with the opposite party number 1, her husband, but the opposite parties did not let her enter the husband's house without the demanded money and furniture. The aggrieved parents do not have the ability to give the money and furniture demanded by the opposite parties as dowry. Therefore, the victim is helpless, taking shelter at her parents' house. The aggrieved person, her higher secondary final exams and wanted to study for a bachelor degree.
My lord, any order from the court, my lord?
And we have filed our objection, my lord, negative fiction on 25/5, 25/9, my lord, for evidence, my lord. And at any rate, we will settle the matter, my lord, and one opportunity may be given, my lord, by interfering your lordship, my lord. And in the mediation is going on, my lord. If your lordship allow me to settle the matter, my lord, I will definitely try to settle the matter, my lord, at any cost, my lord.
Sir, we refer it to
Lord.
mediation.
My lord.
I will refer it for mediation.
Lordship. And the notice, in the meantime, my lord, notice may be go to the petitioner, my
For
respondent,
mediation, I'll have to issue notice.
lordship.
Then I'll have to call for the records also.
Lordship.
Record also.
Till then, my lord, further proceeding
No.
may be
For mediation,
The other-
stay will be considered by the other courts,
lordship.
but stay cannot be granted.
Lordship.
DV case.
If it is settled in the mediation, then
Yes.
stay.
I'll definitely try to our best, my lord, to settle the matter, my lord. But I will bring our
Mediation court will also issue notice then.
Yes.
Um,
She has to appear.
Part learned counsel, Mr.
A Mubarak.
Huh?
A Mubarak.
A Mubarak for the petitioner, for the petitioners. Nambu nalage. First of the domestic, a DV and domestic violence, a case under the domestic protection of women from domestic violence act 2005. Being DV case number 136/2024 has been brought up against the petitioners by the respondent number 2. First of heard Mr. B. Soma, learned additional PP for the respondent number 1. First of the learned additional PP has accepted notice on behalf of respondent number 1. And thus no formal notice is required to be issued. First of extra copies to be furnished during the course of the day. It is submitted on behalf of the petitioners that there is a scope of settlement. First of the petitioners are willing to amicably settle this dispute with the respondent number 2. Full stop. Issue notice to the respondent number 2. Full stop. This case is referred to the High Court Mediation Center. No?
Lordship. High Court mediation.
High Court Mediation Center for mediation. Full stop. The mediation center may fix a date for mediation and issue notice to the respondent for mediation. Meanwhile, call for the records, call for the scan copies of the records. Scan copy is not required, I think.
Not required if it is settled.
Yes. The a date may be fixed by the mediation center for appearance of both the parties for mediation, and thereafter a report on the mediation is to be furnished on 2 months, 2 months time, after 2 months, within 2 months,
Within 1 month, I will.
Within 1 month.
within 2 months.
Yes.
They will call, then again they have to
Yes.
go. This case is thereby referred to the mediation center.
Copy of this, copy of this order may be
Furnished.
sent to the
Okay.
mediation center.
Along furnished copy of this order to the, who will be the
Secretary mediation center.
Secretary.
secretary? Secretary, send copy of this order to the Secretary Guwahati High Court Mediation Center.
Through registries.
Through the registry of this court. List this matter accordingly after 2 months.
Date may be fixed, lordship. Kindly.
Oh, date. List this matter accordingly on, list this matter on
22nd October.
for report on mediation.
22nd October. Item 16.
May it please, my lord. My lord, POCSO case number 49 of 20.
May it please your lordship. My lord, by this petition, I have challenged the validity of order dated 2/3/19.
Just a
Part-
moment. You have challenged judgment and order, no?
Yes,
We need the LCR. LCR is not here.
that is not required for disposal of it. Because purely it is based upon the documents we have filed. The documents along with our petition.
Only on the, based on the documents?
Yes.
Okay. What is your submission there?
My lord, first of all, what has happened in this particular case, that I instituted the case under the Domestic Violence Act, my lord. And in interim, the London Trial Court allowed me 1 lakh of rupees as the maintenance for myself and my son. Subsequently, they preferred the appeal under section 29 of the Act, my lord. In appeal, it was reduced to 50,000 rupees, my lord. So far, the reduction of 50,000 rupees is concerned, my lord. That is not justified under the facts and circumstances of the case, my lord. For that one, my lord, I am taking to your lordship to the order that is at page 12, my lord, the impugned order.
Page?
12, 1, 2. And directly I am taking to your lordship at page 50.
Page 12 and then page 50.
Page 12 is the order, my lord, impugned order.
Page 12.
Yes. And I am taking to your lordship.
Members. Now, out of which there is an interim relief granted by the Honorable Trial Court
Yes.
amounting to 1 lakh.
Mm.
That was challenged in way of appeal.
And
That
in the,
can-
Which is allowed as the last one. Respondent number 1 has not declared any merit of maintenance period. VWA issue written unexecutable. I am giving the more distress of this unexecutable. Because so far the distress warrant of arrest is concerned, that was issued earlier to it. And that order was issued, my lord, on, I have the copy, mine, on 18/6/2021. 18/6/24. 18/6/2024. He has not challenged that order. Or he ought to have challenged that order, not this order. Because
yeah, yes,
First
yes.
point.
Mm.
Now, second point, my lord.
Definitely.
Regarding this order, it is an interlocutory order, my lord.
Mm.
First of all.
Yes, yes.
Secondly,
Mm.
appeal lies under section 29 of the
Yes,
Domestic
yes.
Violence Act.
This is not an
Any
appeal.
order. He has not signed any kind of appeal. Now,
No,
under
no.
section
No.
397.
Not maintainable.
My lord, the revisional power is extended
No.
to the certain area. Lord,
No.
I will satisfy that even there is a provision for appeal. If the order is prima facie shows that it is not passed in terms of the law, the Honorable Court can exercise supervisory power. Here is a case that whether this supervisory power can be exercised in the light
No.
of the impugned order. Lordship question is that the distance warrant that has been issued, there are certain formalities to be observed in order to issue a distress warrant.
Then you would have ought to have appealed.
Absolutely. Lordship kindly see that there are certain citations which clearly say that even there is a statutory appeal lies, but even then also a revision petition can be filed. The revision petition is only limited to the extent of to see the perversity, nothing more than that. Mate of the case, I am not challenging. I am not saying that what is the mate of the. I am saying that the order which has been passed in a way is not sustainable in the eyes of law. Lords, it's a matter of hearing. If my learned friend want to raise the issue,
Admit.
Your
Lordship-
lordship has already had.
the Lordship
What more
kindly
is
kindly
required
see
to
that
appeal?
if suppose they would like to say that out of this appeal is maintained for a moment, take it for a moment.
No, I have judgments also.
No.
I do not know. I have judgments.
That's why,
of
Lordship, what I am saying.
Coordinate bench
Yeah,
also.
no problem, Lordship. Just give one date on the basis of that. I would like to address this honorable court. If Lordship feel that no, this is not a fit case for suppose revision, definitely that will be my lord. I will be disentitled.
I can
But
give you
at
a
least
date,
one
no,
opportunity I have to be given.
I won't be convinced.
No, Lordship, one
Definitely.
opportunity to be given so that I can address.
My lord, this is the total dues I have to issue 20.
Again, coming to dues, it's just a piece of paper and he wants to claim rupees 20 lakhs. Wherefrom I will pay?
I have given.
Lordship, kindly see that. Just look for a moment, Lordship. Why this revision petition maintainable? Lordship, page 24 for a moment.
No. It's not maintainable.
Lordship, kindly see, page 24, for a moment only. My lord, this is the court which is exercising in-hand power, my lord. Ample power. It cannot be circumscribed to the limit of appeal only. Lordship, page 24. Lordship, kindly see 13/3/2023 balance as on 13/3/2023 rupees 15,50,000. And they on that count a distance warrant has been issued.
So you could have appealed.
That's why, Lordship, I'm saying appeal is a matter to be dealt with once I tested the merit. I would like to say there is non-application of mind by the learned court below. The power which is bestowed by the learned court while exercising distress warrant, formalities are there.
First of all, that order, hey, the protection.
Lordship, kindly see 397 or my lord 40 power is very much clear.
Protection of women from domestic violence. This is before the BNS, no?
My lord?
Before BNS.
Yes. No, not BNS, my lord. I'm because this is a old act I have filed.
Old
earlier.
act, yes.
Lordship, may I submit one thing only? Because on next date, no, Lordship, in suppose this way, Lordship dealt with my subject matter, then I will be deprived, my lord, because ultimately I will be sufferer. At least one chance may be given so that I can address on the basis of if Lordship feel that no, this is not maintainable, I will withdraw, my lord.
Okay. No, you cannot withdraw. Revision petition, you cannot withdraw.
Lordship, I will get a.
Even if you withdraw, I will have to dispose of
Definitely,
on pen.
Lordship, I will pray for liberty to file appropriate application before the appropriate form is required. But if suppose, take for a moment, if I would be able to satisfy this honorable court under these circumstances, even revision is maintainable. It becomes a academical discussion. Just give one chance.
See, I have already disposed of 2-3 matters
All,
in this
my
ground.
lord, all cases have its own features and nature. Here is a case, my lord. I just want to address only this one point that even there is a appeal under the law, but if certain circumstances demand, then revision is maintainable. Out of which 397 power 401 can be
It's
exercised.
okay, I can give you a date, but I don't think you will be able
Yes,
to.
my lord, only
convince
one
me
date
of the
may be
next
given.
date
Lord.
also.
One date may be given.
Okay, one date. Because I have given you one date. You also come with a revision petition. He is also come with a revision petition. Okay. As agreed by the learned counsel for both the sides, list the matter on 5th September. Along with that case only.
Yes, ma'am. Better.
Same day. Yeah.
Item 20.
Oh, এইটো গুচি গ'ল নেকি? এই ইয়াৰ লগত হেৰিটো গুচি গ'ল নেকি? First listখন গুচি গ'ল নেকি? No.
May please, your lordship.
Yes, yes.
My lord, this criminal petition is basically for quashing of the FIR dated 8/10/2023. So my lord will please to find the FIR at page 13. The allegation in the FIR is basically carrying of gold bars, illegally carrying of gold bars. The allegation is there. My lord will find at page 13 the FIR, my lord.
This is for admission, no?
Yes, my lord.
So it will be final submission then.
My lord?
Final submission.
Yes, yes.
Who is on the other side?
Government, PP.
Only government, no?
Yes.
Finally, I'll hear it. Hmm?
Not today, my lord. I've not gone through the LCR.
Let him go to the LCR.
My lord, every occasion, I'm not objecting, but every occasion, some another additional PP has appeared. On the last occasion also, honorable coordinate bench was supposed to dispose it of you, but take a chance, just gave them a chance. My lord, a date may be fixed, my lord.
Learned counsel Mr. B.M. Deka is present for the petitioner. Learned additional PP Mr. J. Sutia has submitted for time to go through the trial court records. List the matter on
3rd September.
Okay.
In interim order may be continued.
Interim order shall remain in force till then.
Much obliged.
Item 21.
Records have not come in.
Trial court record as called for is not received. We should reminder list the matter of.
On
After 2 weeks, madam.
2 weeks.
You are on interim.
I'm on interim.
Interim order shall remain in force till the next date of listing. 2 weeks day after till the next date of listing.
I'm deeply obliged.
Item 23. Met Your Lordship.
Hmm.
Now, see, this revision has preferred against the impugned order dated 27/2/2025, which is at page 62.
You're for respondent number 2, no? Okay. POSCO case?
No, Your Lordship, it's regarding a Jimma. The Jimma has.
Okay, Jimma, okay. Any report has been called for relating to the Jimma?
Hmm,
Jimma what?
Jimma of a vehicle, two-wheeler bike, Your Lordship.
Case is disposed of or case is still pending?
The trial is going on in the learned court below,
Trial is going on.
but the Jimma petition has been dismissed by the learned court below.
This Jimma petition has been dismissed.
Against that particular order,
Do we have the LCR?
Yeah, I think, Your Lordship,
Why?
it's not been called.
You are respondent number 2, you are a complainant.
She is the owner of the vehicle,
Oh, you are the owner of the vehicle, okay.
and I'm for the finance company. I'm for the financer.
Okay.
They have defaulted in making payment of the monthly installments.
There is a tragic incident, Lordship, and though the vehicle is in my name, but it was run by my son, and he was killed by some local youths of that area, Lordship. And thereafter, the vehicle is seized by the concerned PS, and the vehicle is lying on that concerned PS. But since then, I am the defaulter of the.
Since December 2024, they are not paying the monthly installments. And being the finance company, we have approached the learned court below,
And court below has
rejected our prayer, Your Lordship.
But
Where is the prayer rejecting? Jimma?
Page number 62 is the impugned order, Your Lordship.
What PP, what the PP does have, what does the PP have to say? Where is the impugned order? Wait.
Page 62, Annexure 6, Your Lordship. It's order dated 27/2/2025. Passed by the SDJM Rangia. If may I read it, Your Lordship. Today, the matter was fixed for Jimma report from the IO and hearing on the Jimma petition number so-and-so. The petitioner is represented by his learned engaged counsel. Heard, report as called for is received from the IO concerned. Peruse the same, wherein it is stated that the seized vehicle bearing registration number so-and-so is required for the investigation of this case as the investigation is on progress.
Investigation is not complete.
It's completed, Your Lordship. They have filed charge sheet and now it's registered as PRC case number 44 of 2025. The owner of the seized vehicle is Srimati Mandonath, that is my learned friend is representing, Your Lordship. And the Jimma petitioner is not the actual owner of the seized vehicle. Peruse the case record. Considering the facts and the report of the IO, the Jimma petition stands rejected. Petition number so-and-so dispose of accordingly.
But what about her submission? What is your submission?
see, I have no objection if the vehicle is
Taken over by them.
Because it was run by her son who expired.
Who has
this
been
particular-
killed. And then in connection with that case, this vehicle was seized.
Was seized. And since December till August, it's been 9 months, they have not paid a single installment. So the finance company is suffering.
Can be handed over, no?
Lordship, the installment part, Lordship, there was bank installment, Lordship. So I am unable to pay the installment, Lordship.
That is why they are taking over the vehicle.
Lordship.
That is why they are taking over the vehicle.
Yes, Lordship. But the balance amount, Lordship, I have to pay the installment. If they consider my amount, Lordship, I have no objection.
And that can be done amicably outside the court, Your Honor. She can approach the branch manager, I'll inform the
No,
branch.
no. Then this way I'll not hand over the vehicle. We'll call for the record,
Lordship,
huh?
Lordship.
Trial court record.
Lordship.
And then meanwhile, you decide what you.
Lordship.
You settle the dispute.
Lordship.
Huh? Then meanwhile, we'll call for the trial court record.
Lordship.
Learned counsel, Mr. G. Bodle is present for the petitioner, learned counsel, Ms. G. Deka is present for the respondent number 2, and learned additional PP, Mr. J. Sutia is present. Call for the scan copies of the trial court record. List the matter on, then you settle them.
Lordship, in the meantime, I'll settle.
After 2 weeks. How many installments you are about?
They have left 9 installments.
9 installments you have to pay. I think it will be settled.
Obliged, Lordship.
Item 24.
My lord, for quashing of the FIR in the charge sheet, my lord.
Mm.
Now here is the case where, my lord, the case rests on promise to marriage, my lord.
Mm.
And my lord, at the stage of motion, my lord, this honorable court was pleased to report that on the appearance of the respondent number 2, the prayer for entry would be considered, my lord.
Mm.
Only part is that I have gone through the records have been there also, my lord. They have already appeared on the last occasion.
Mm.
My lord, if your lordship goes to the state, also there on the record, my lord. Previously, while I moved the applications, my lord, those judgments are also there. I'll take this judgment, I'll place.
Yes.
Again,
on that-
I'm obliged.
We please your lordship. Lordship appeal against conviction.
Okay.
POCSO matter. LCR
Issue
will be
notice?
required, lordship.
We'll admit it. Appeal against conviction, we'll admit it. Lordship. Learned counsel, Miss S. Begum.
And Sultana.
And Sultana is present for the appellant. Who has preferred this appeal against the judgment and order dated 10/7, 2025, passed by the learned. Special Judge POSCO in connection with special POSCO case number 20 of 2019. Convicting the appellant under section 4 of the POSCO Act and sentencing him to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 with default stipulation. Third, Mr. J. Sutia, learned additional PP Assam. Admit petitioner to appellant to take steps to issue notice to the respondent number 2. Have you read respondent number 2?
Yes, lordship.
Call for the trial court records. Place the matter on after 3 weeks. Respondent number 2, returnable in 3 weeks. Last one, list accordingly.
Lordship, if possible, may fix a date.
Date right?
On
the
end of September.
September. Returnable on 18 September. That last one, fix 18 September.
Item number 26.
Lordship, this is a legal aid matter.
Hmm.
The engaged counsel is at other court, your lordship. After maybe taken after some time, your lordship. This is a legal aid matter. The engaged counsel is at Lakes in court number 19. Maybe taken out after some time, your lordship.
Item number
After some
27.
time.
For April.
That is lordship.
My lord, kindly see, my lord, item, order dated 26/6/2024-25, lordship. My lord, 2 affairs, lordship, one was my father and another is my mother, lordship. On that day, lordship, 26/6/2025, lordship, CD was period by your lordship, and after going through the, my lord, ossification test and the birth certificate obtained after, my lord, 4 years, lordship. And your lordship also, my lord, had gone through the, my lord, ossification test, lordship. Then, my lord,
annual health pilgrimage. Now, the money I have taken, I have admitted in my petition clearly. And I have also arranged visa, etc. for them.
No, you see, this bail petition, I have taken
In 2 cases, your lordship,
orders. I have passed
your
orders.
lordship
I
has
have
granted,
granted bail.
granted bail.
After they were arrested, I have granted.
No. In the anticipated bail.
Anticipated bail?
Yes.
No, I have not granted.
Kindly
anticipated
see,
bail.
this is their principal accused in this case. One I have annexed page 88. And another is, he is the main accused in this case. He has been granted anticipated bail, first interim bail, then absolute bail. It is another. In the same case, another person has been also granted bail.
Okay.
And my role, my lord, I have admitted that I have taken money, I have arranged everything. They are not going to Umrah, what I can do? And that's why your lordship has granted bail to other co-accused persons.
Your person is not the main accused.
No. Kindly see the FIR.
We'll need the CD.
No, kindly see the last order, man.
No. We'll
Kindly
need the
see the,
CD.
no, kindly see the last order.
No, I won't see. I will need the CD.
No, last time your lordship observed that if city does not come, interim bail may be considered. Kindly see.
Mitali Thakuria, not me.
Hello?
Another bench, not me. CD has called for is not received. Issue reminder list the matter on
8
But,
September.
8 September.
But interim, then at least you.
30.
And then IO may be asked to appear personally because he is not sending CD. One after another, he is not producing. I am suffering. My business has been stalled.
I'll produce in a link.
Positively CD. Issue
Otherwise-
reminder to
otherwise, my
positively
lord-
forward the CD. For the CD. Issue reminder to positively forward the CD.
And if CD does not come, bail may be
No
considered.
consequences will follow.
Of course, that is so because earlier also that order was passed.
Item 30.
Second anticipated bail application lawsuit. Earlier, it was rejected on 9/5/2025. The grounds for one of the ground of rejection was that investigation is still under process. One of the ground of rejection. The second bail application lawsuit. Now, say the FIR against us.
Then 103,
Lordship,
that murder case.
lordship. But I
You have the CD?
scan copies. PCI was called for.
It was received.
Scan LCS.
You have any objection?
Yes, madam, because there are lots of materials are there.
I have to submit something, Lordship. I may be allowed to submit for my satisfaction. It is a decision of this honorable court. Yeah, Lordship. It is the FIR against me is page Lordship 31. Also, no, page 23. Lordship.
I know the case. Why do you have to show me the FIR? I know the case.
Lordship.
I'll go through it and I'll pass an order.
Lordship. Now, one thing is that Lordship, earlier, we have first lost the FIR, Lordship. On the basis of our FIR, the disease, now disease was.
See, I will scrutinize everything. Sasid has been submitted against you.
Lordship.
Why? Why Sasid has been submitted against you?
Lordship, Sasid has been submitted. Lordship, my prayer is to, before this honor.
Why?
Lordship, my prayer is.
This is saying that you were not assaulted, you fell down
Lordship,
and you
Lordship.
injured your head and
On
then
that
you
context, only.
died because of the injury. Then
Yes,
why did
Lordship.
the police submit Sasid?
Yes,
against
Lordship.
you?
Yes, Lordship.
Why don't you report this to
Lordship,
SPEC?
my prayer is that I seeking permission to submit something, Lordship, for my satisfaction. No, otherwise it is discussion of this honorable court. Lordship, at first, we lost the FIR, Lordship. It is our FIR on Lordship page, page, page 23. It is translated page on 17, Lordship. It is against us, Lordship. The one Sampadaka lost the FIR. I have the honor to state that on last 13/3/2025, my younger brother Sri Laru Gopal Rai mistakenly entered into the Betelnut orchard of accused number 1 at around 11 p.m. After consuming liquor, supposing him to be a thief, the accused persons had assaulted him severely and thus caused injury on various parts of his body. Now being referred from Tezpur Medical, he is undergoing treatment at Jamshed's. Incident took place on 13/3. His FIR was lost only on 15/3. And next, page 17, Lordship. Page 7, page 23. Page 23, Lordship. Sorry, Marana. Page 25 is the FIR lost by us. It is the FIR lost by my elder brother, Lordship. It is on 13/3. I have the honor to state that on 13/3/2025, around 11:15 p.m., while I was coming back to my house after attending Kirtan at the house of one of my neighbor, I saw the above cited accused was plucking betel nuts from my orchard behind my house. I went near him and caught him red-handed with the stolen betel nuts and the sickle with which he had plucked the betel nuts and then handed him over to the police of Ikabari Police Outpost. I therefore earnestly pray to your good self to kind enough to investigate the matter.
See,
Lordship,
please, please.
thereafter, Lordship,
You see, I have granted bail, anticipatory bail in a case. This is not on the POSCO Act. That is why I have granted.
But
Now you don't
page
expect me to
33
grant bail in
Lordship, page
anticipatory
33
bail in 103.
Lordship, page 33, Lordship. Page 33 is an intimation letter by the police personnel. We handed over the arrested accused person, Lordship. They took the disease
case.
Lordship. He fell down in the
I know.
police premises, Lordship,
Yes,
and he was to toilet, Lordship.
So why did the
Then-
police submit charge sheet then?
Then, Lordship, may I be submitted? Am I supposed to look into the second circumstances? Lordship, so see the
No,
medical
no,
report.
no.
Kindly see the first medical report, Lordship. What the first medical report says, Lordship.
Then you have first medical report,
Yes,
second
sir.
medical report. Then why did the police submit charge sheet? Why?
No, it is I think the second FIR is counterblast of our FIR, Lordship. My prayer is that. There's nothing happened, Lordship, in our custody. We have handed over the accused person in a very good condition. See the medical report, kindly see that. I have typed the medical report, which we get this one through RTI, Lordship. See the ML 93, Lordship. It is on 11:30 PM.
See, please, you take this before the trial court. I'm not going through all this RTI medical report and all this.
Lordship, then the FIR, Lordship, the forwarding report of the police personnel, they have stated that even the deceased person never produced before the judicial magistrate.
The trial court will consider
No,
your
he was
case.
never produced, Lordship. What is
Withdraw
that?
a petition.
It's a violation of Article 22, Lordship. He has never been produced,
See
Lordship.
what you are coming to. You withdraw a petition, you go before the trial court.
Lordship, and my wife is also pregnant, 7 months pregnant, Lordship.
I'm giving you a good suggestion. You withdraw a petition, you go before the trial court. If the trial court rejects the bail
There's a
application and
technical,
forces to custody,
technical
come before
difficulties,
this
Lordship.
court.
Since it is a 103, charge sheet has been submitted before the ZMFC. The ZMFC cannot consider our petition, Lordship.
You
That's the
are,
problem.
how many, you are 4 brothers and sisters accused in this case. Same day you appear, the case will be committed.
Not for two brothers, Lordship.
Maybe 2 brothers, maybe, I don't know.
I will protecting, Lordship, imposing any conditions, Lordship.
No way.
It is a charge sheet submitted in the ZMFC, Lordship. I mean,
How can you
company.
bring one RTI medical report for bail?
So everything happens during the police custody period, Lordship, not in our
Why
custody.
didn't you give this during investigation? RTI medical report?
Lordship, one thing is
Why,
that we have already
seeking investigation by the CBI then?
Lordship, I have already lodged a complaint before the SP, Lordship, regarding the custody. See, it is received by the SP, Lordship.
PEC,
Lordship,
SP.
yeah,
See, no.
it is received by the SP office, Lordship.
I'm passing an order. I won't grant bail.
Lordship, imposing, I'm a government employee, Lordship. I'm a community health officer. I cannot be a murderer, Lordship. Cannot be, Lordship.
No, but
Imposing
you
any-
assaulted him.
Lordship, though it is search.
There are witnesses who have stated you have assaulted him.
Lordship, FIR, if we compare the FIR signature and the FIR
You
handwriting,
all
Lordship,
assaulted him and he died as a result.
No, I
Because
have
of
to-
stealing Tamul.
he died during police custody, Lordship. After 7 days.
Have you seen the photographs?
Yes, I have seen. it.
Lying in front of
Yeah, I
that
have seen.
bunch of Tamul?
I had seen that.
That time he was half dead.
When he was in police custody, Lordship, without the knowledge of the police personnel, he went to his home, Lordship. Thereafter, police again bring him, then send to him GMCH, Lordship, without escort, Lordship. He died after 7 days. The injuries got here on the 14th, kindly see that these are fresh injuries on head.
This is
On
AB, no?
13th, there was no injury. He was under alcohol, influence of alcohol. It is stated in the medical report, Lordship. On 13th, there is no serious grievous injury, Lordship. Then everything has happened after 14th. Till 13th to 15th, he was not produced.
Somebody is hit on his head, then what case is registered under section 325. Then after 5 days, he dies. Then who will kill him then?
After 7 days. No, not trial. What about the Constitution 22(2)? You're supporting the police personnel. Wait, they are doing a blunder mistake.
What
No, no,
about
I'm
the
asking you.
constitutional rights of the person?
Listen, with permission, man, I want to ask the PP, the custodian of the civilian. You are representing the state. You are representing the state. What about the Article 22(2)?
Because of stealing Tamul, what about his
He was not
constitutional
produced.
rights?
Lordship, he is representing the
Learned
state,
counsel,
but without
Mr.
preparation, he is here. Sorry. About the constitution of what can I have, please?
P.K. Soria for the petitioner, Khayyam Nehar, Elias
Using any-
Nehar,
My prayer
was
to
filed this application
any
under
protection, Lordship. So I'm a community health officer. My
482
wife is
of the
alone in my house. Lordship.
2023 with prayer.
He's 7 months pregnant.
As is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Third, Mr. MP Usami Laner, additional PP Assam. The allegation against the petitioner is that he, along with his
The second FIR is a Lordship counterable as a borrow FIR, Lordship. Till appearance, Lordship, I may be protected. Let's say it is fixed on 11/9, Lordship. For few days, Lordship, so that I take care of my wife, Lordship. It is maybe in last week of this month, Lordship. Expected date of delivery, Lordship. My presence is very much necessary, only on humanitarian ground, Lordship, for few days,
I'll pass an order later.
Lordship.
I'll pass an order later in the chamber.
Lordship.
I'll submit, I'll record all your submissions.
Yes, Lordship.
I'll pass
I
an
need
order
it,
later.
Lordship. Deeply blessed.
Supplementary cause list item 49.
May it please your lordship.
Blue color pencil is not like blue vanilla pencil. Yes.
Lordship, in this case, lordship, TCRs were called for, lordship, that has been received. On the last occasion, after
Speaker. Yes,
lordship, on the last occasion, lordship,
not working. It's okay. It's okay. It's okay, okay. I can hear you.
lordship, on the last occasion, lordship, after hearing me, lordship was of the view that perusal of the statement of the witnesses are required. I have checked, and lordship, the witnesses, there are, lordship, 6 witnesses are there, lordship. On the last occasion, lordship, my
DPS case.
no, lordship. This is a case of lordship 103, lordship 302. 302, lordship. My prime ground is that, lordship, nothing is there against me. The petitioner is aged about 68 years. Lordship, may kindly come to the FIR for a moment, lordship. Page number 16. One six. The name of the petitioner is there at serial number 6.
Yes.
May I read the FIR, small FIR. With due respect, I state that the reason taking shelter of law is that one so and so at around so and so, the above mentioned accused persons came to the residence of the husband of my daughter, namely so and so, along with one so and falsely alleged that there is a so and so relationship between my daughter and the said so and so. Thereafter, the hands and legs of both of them were tied up, and they were beaten them with an intention to kill both of them. As a result of the assault, both of them suffered severe injuries. On getting the information, I went to the residence of my daughter, and somehow I took my daughter first to so and so hospital, thereafter so and so. But while we were on the way, my daughter succumbed to the injuries.
Okay, okay, I remember the case.
Yes.
Let me check. What do you have?
Well, the LCR I have not checked my.
Let him go to the LCR.
On the last
I-
day, lordship,
I'll after going to the LCR, I'll
Let
make.
him go to the LCR.
I'll make that function.
that much only, lordship. My prime.
I'll go to the 161 statement.
Yes, yes, lordship.
Sidde Kali, I'll go to the
Yes,
statement.
and my.
I will,
Yes, yeah.
yes, I'll check and tag mark my lord.
I cannot hear only one side.
Yes,
I'll
yes.
check
Let
mark.
me hear the copy.
Lordship is taking up this matter after some.
Whenever he finishes.
I'll tag mark and you'll not.
Lordship,
Mm.
here the service is complete because the counsel of the respondent has appeared.
Mm.
The matter, the IA matter relates to condemnation of delay. And the main case is the check
How many days?
bouncing on check, NA, the main case.
Delay of how many days?
This is the condemnation of delay. Hmm?
How many days?
How many? Oh, yes.
216 Lord.
You have any objection?
Yes, Lord.
What are the grounds?
The ground is there, the medical ground. We have submitted the medical.
Which paragraph?
Pardon?
Paragraph of your petition? Okay. Paragraph 3.
The entire we have submitted with annexer. There are 4 medical certificates. Annexer 2. Annexer 2. Annexer 2 deals, this is the case number 17. Then another is annexer 3. That is also another certificate. And thereafter, there are 2 certificates. One is 5 and another 6. The Lordship, in the meantime, the judgment was delivered at 12th December. In the meantime, COVID.
It's okay, it's okay.
COVID started.
It's okay. I have read it too.
Yes,
So-
Lord. Here, Lordship, conduct of the petitioner is totally malified. The check bounce case, it is check bounce case. Check was issued in the year 2014. Then 15, this case was filed. After, at the time of final argument, he has taken 3 adjournment. On the fourth date, he come with a petition that I want to settle the matter. So before the submitted before the court. Accordingly, court referred before the district mediation. In the district mediation, after 2 sittings, matter was settled totally. A memorandum was prepared before the district mediation center. Then where he agreed that he will pay the check amount. Thereafter, he filed another petition before the trial court that he needs some more time.
You have submitted any?
Yes, Lordship, I'm coming to Lordship. So after that, the trial court granted him another 1 month time. After that, he filed a revision petition before this court, stating that he has been by force sent to the mediation center, and the mediator by force took his signature in the memorandum by taking that plea. This revision was filed before this court. Ultimately, this honorable court dismissed that revision. So thereafter, the trial court convicted him that the appeal was filed. If we does not exclude the delay period of COVID, then it's a total days of 121 days. 1021 days. So the medical certificate here exhibited, let's kindly see.
No, I've seen.
No date. Doctor said that he is a diabetologist. He treat him for all illness.
I have seen.
First
All.
certificate, his treatment, typhoid fever, along with jaundice. Next certificate, suffered from ischemic heart disease. He is a diabetologist. He heart disease also seen. He typhoid also treatment. Jaundice also his treatment. Next, there is another certificate, 2 certificates.
It's okay, it's okay.
Same doctor, Lordship. So there is no bona fide ground, Lordship. The case of 2014. Last 2 certificate, same doctor.
So all these years, he did not pay the amount also.
No, not paid, Lordship.
He's not on bail.
Not on bail.
So why that order could not be enforced? For so many years?
Because trial court has once issued a warrant,
Hmm.
is avoiding that. So that is the difficulty. Therefore, I have mentioned this before this court for listing. For a long period, the matter has not been listed.
What is the amount? 90,000?
75,000. He has agreed to pay 1 lakh.
Okay, we'll condone the delay.
If lordship is condoned that delay, then matter may be fixed for a final argument in a short date lordship. It is the
Yes.
case of 2014 lordship.
Yes, yes.
Otherwise, he has no merit. I have annexed this memorandum of understanding also in my
Condone the
objection.
delay. And we are not, this is not even registered also.
Yes.
It will have to be registered.
They may be directed to serve the copy of the criminal petition by Tuesday.
Okay. Third learned counsel, Mr. UC Rabha, for the petitioner. Gautam Sinha Roy. Who is the petitioner?
Gautam Sinha.
Gautam Sinha Roy. Gautam Sinha Roy.
Yes.
Gautam Sinha Roy,
Sinha Roy.
who has filed his application under Section 5 of the Limitation Act 1963 with prayer for continuation of delay of 214 days. For filing the criminal revision petition. No, this is not 214 days. That argument judgment was in the year
No, in the
2019.
COVID period, lordship 700.
Okay,
That period is minus. Otherwise, it is a 1021 days here. Therefore, I am objecting, lordship. It frustrated the very act also.
214 days on filing the criminal revision petition against the impugned judgment and order dated 21/12/2019 passed in criminal appeal number 105/2017, whereby the learned appellate court upheld the conviction and sentence passed by the learned trial court by judgment and order dated 12/4/2017 in CR case number 1001/2015 under section 138 NI Act. Heard Mr. MP Goswami, learned additional PP Assam, and learned counsel Mr.
S. Deka.
S. Deka for the respondent number 2.
Respondent.
It is submitted on behalf of the petitioner that the petitioner was applicant, petitioner. On behalf of the applicant, that the applicant was well aware of the impugned judgment and order dated 21/12/2019. But the applicant was ailing. Host of the applicant has relied on the decision of the Honorable Supreme Court in suo motu WPC number 3/2020, whereby the period of limitation during the COVID pandemic was extended from when?
From 15/3/2020 till 28/2/2022.
15/3/2020 up to 28?
To 2022.
28 to 2022. On the contrary, the learned counsel for the respondent number 2 has submitted that the petitioner has not shown sufficient grounds for condemnation of delay. His malafide is evident from the from his conduct. To stop earlier, there was there was amicable settlement between both the parties, and a what agreement was executed.
Yes, Professor, that is enclosed.
And then
MOU.
Huh?
MOU in my objection at page.
And an agreement was executed between the petitioner and the respondent number 2, whereby the petitioner had agreed to
Page 35 of my objection.
pay the compensation of rupees, how much?
1 lakh.
1 lakh.
Paragraph 4.
Thereafter, the petitioner failed to pay the compensation, and thereafter what happened? What was the submission? I've forgotten.
He again paid for extension of time. That was also allowed for 1
And he paid for extension of time, which was also allowed by the learned court,
court.
trial court.
Trial court.
Thereafter,
Then he filed revision petition that by force he has been sent to mediation and the mediator by force signed took his signature. This revision petition order at page 37.
meanwhile, the petitioner preferred a revision petition, which was
Petition number, criminal petition 201/2017.
which was disposed of with a direction to approach the mediation center.
No, no,
No,
dismissed, Lordship, not
which was
disposed of.
dismissed.
Yes, Lordship.
Which was dismissed. Full stop. A memorandum of settlement was also that was executed. in the
Yes.
District Mediation Center.
Yes,
Which is marked as
annexure 1, Lordship, in my objection.
one of the
Objection, Lordship.
objection
Yes.
held by the respondent number 2. Full stop. I have scrutinized the medical certificate submitted on behalf of the petitioner. Full stop. It appears that the petitioner was suffering from sepsis since 4/7/2022. Full stop. Earlier, he was suffering from dengue since 1/4/2022.
Typhoid also there.
Hmm?
Typhoid also there. Jaundice also there. Then ischemic heart disease also there. Heart disease also there, jaundice, typhoid, everything he has, and the same doctor is treating.
Why don't you pay the amount?
What remains in the revision, Lordship? They are by
Why don't you pay the
agreement.
amount?
No evidence, documentary evidence they have lead. Simply denial.
Earlier, the petitioner was also suffering from heart ailment, from a jaundice and typhoid. I don't think so. I'll condone the delay in this manner.
Yes, Lordship, kindly see the finding of the appellate court, Lordship. Trial court judgment he has not annexed. Appellate court judgment, Lordship, I am reading a specific paragraph. Page 15, Lordship.
See, why have you annexed so many certificates?
Here is no corroboration.
Jaundice, typhoid, can one person suffer from? so
All
many?
ailment he has and the same doctor is treating. He remained in Guwahati for filing what he prevented him. And finding of the appellate court, kindly see, Lordship, paragraph 15. Page 15, Lordship, paragraph number 25. since 2014.
I don't think so. I'll condone the delay.
Totally malafide laws. It's a manufactured document. How he can diabetologist, he treating for everything, every ailment. 1071 days, 21 days, totally.
Lordship, after the expert's opinion, medical certificate, we cannot say it is.
And this medical certificate are not supported by any prescriptions.
See,
That
this
is
is a
how the
court,
record.
you cannot.
Because
this
medical
is-
certificate is the expert opinion. How can I deny?
You cannot, supposed to be a kangaroo court or something like that of
The
that
other
sort.
things are we are not aware of.
You see, one person, Iqbal Hussain, is saying that he's suffering from jaundice from 14/3/2020. Then he is suffering from,
First, he stated that
what, I don't know what type of heart disease, ischemic or what?
is first certificate said
Ischemic
recurrent
heart disease.
typhoid.
Heart disease
Language is also
15/2/2022. Then he was suffering from dengue from 1/4/2022. Then he is suffering from sepsis from 4/7.
sepsis and UTI, urinary tract infection. Urologist also he. He is a diabetologist. How Lordship, this type of certificate can be without supporting any documents?
Saying that
Yes, so far the certificates are concerned. With a medical opinion, we cannot say it, we cannot deny it.
Not a single
They-
prescription
they-
medical
they-
report has been
what
executed.
The disease is there, it was examined by the expert, doctor. He opened it, he gave certificate. So what can I do? What should I do? That is my point.
no, you cannot count 1,000 in all these days.
So
Yep, I cannot convert, conduct has to be seen, Lord. So it's a whether it is a bona fide or bona fide. These are not bona fide. He remains in Guwahati for filing.
Conduct of the applicant.
Supreme Court has excluded, that is a different thing.
It is not the issue of conduct. What is the
See,
conduct? Conduct does not come here.
You are before a court.
Only the question is regarding the payment.
No, this is not,
Other conducts are
this is not acceptable. You are before a court. Then you bring 4 or 5 certificates by the same doctor, then continuously he's suffering from this type of disease, then thereafter this is
No
not
discharge
acceptable.
certificate, no investigation report, no prescription, only the certificate.
I also cannot say about that. He simply said medical certificate.
No, this is
submitted.
not acceptable. You are before a court, you see.
I have not. nothing
It's
to
not
say.
AI, it's meant by a person here, not AI, artificial intelligence. You cannot submit this type of certificates in this manner. I'm rejecting it.
Obliged.
Yeah. Document here. Notebook के माना गया है।
It's really very good.
नोटिस के लिखा हो। ये क्या है?
More medical certificate become transfer from us. Really very good. More different billion na. Target different আছে. Episode আগত এখন আছে পিছত তিনিখন আছে। গোটেইখন একেলগে চিৰিয়েলি ধৰা দিলে মই ডেক কৰি দিছো। Where is the appeal? At which page?
Appellate judgment, Lordship. Appellate judgment at page 15, Lordship, paragraph number 25.
এইটো বুজি নাপালে ন পিছফালে টাইপ কৰাটো আছে বেমাৰটো বুজি নাপালে পিছফালে টাইপ কৰাটো আছে ইনপুট কৰি দি চব পিংক কালাৰ টাইপ আছে It appears that the medical certificates are submitted to accommodate the gap whence the time starts running out. I'm rejecting it.
Obliged.
Always the appellate judgment one.
Page 15, Lordship, paragraph number 25, finding purpose.
Petition.
আগতে ৰিভিজন কৰিছিলে নে কিবা?
Dismiss clear.
আমি নাজানো। Anyway.
You can settle through
Yes,
some
sir.
mediation center or something.
Yes, sir.
Bring down the interest rate.
Yes.
7,000
Already
rupees at
settled,
least.
interest that is also waived in the agreement. MOU, I have annexed also in my objection, annexure 1. That is also an.
Master Prince.
Obliged.
Item 32.
Maybe pleases you, Lordship. Your Lordship is perusing to office note dated 28/2025, service completed upon respondent number 2. A short date may be given, Your Lordship, for admission hearing. Taken steps through local OC.
Service is complete, no?
Yes, Your Lordship.
Twenty.
28/2025 of office note. Sure.
Council Miss M. Decano.
MSP does.
M. P. Das. Miss P. Das is present for
Representing
the-
as legal aid counsel.
Or learned legal aid counsel, Miss P. Das is present for the petitioner. Your correspondent number 2? Respondent number 1. Learned counsel, Mr. B.K. Sen is present for respondent number 1. Office note dated 20/08/2025 indicates that the notice has been duly received by the respondent number 2. LCA has been called for.
Your Lordship, not needed, Your Lordship. I already annexed it, Your Lordship. That lower court order.
You want the
was
LCA?
over.
Lordship may call for the LCR because
Scan copies of the LCA.
Scan copies.
scan copy will do, yes.
Call for a scan copy. We'll place it in the admission column.
Yes, Your Lordship.
Call for a scan copies of the trial court records. List this matter for admission.
List on
Date.
16 September.
I'm deeply obliged.
Timing item 49 for bail hearing.
Yes, it will.
And the petitioner was arrested on 9/3/2025. As on date, Lordship, 167 days. Otherwise, Lordship, the offense, Lordship, is very serious. And my submission would be, Lordship, in as much as, Lordship, 12 persons are named in the charge sheet. Amongst those 12 persons, 5 were already granted, 5 were arrested. And out of those 5, 4 has been granted bail.
Okay, you have anything against it?
Yes, my lord. Lordship may kindly see the page, others I have flag mark, my lord.
Yes.
Page 53, my lord, how brutally, my lord, these 2 persons were assaulted, and because of that, the lady died, my lord. If page 53, your lordship can come, my lord.
That is, this, CD?
Yes, number the petition, my lord.
Oh, page 53.
Petition, my lord.
That I know.
During
Last occasion,
investigation.
Lordship, I read it,
Yes,
Lordship.
yes.
And the lady was confined in the Siddiq Ali's house, my lord, and thereafter all the persons, my lord, including this petitioner, my lord, have assaulted very badly, my lord, and due to which, my lord, 6 succumbed to, my lord, death, my lord. It's very pathetic, my lord. So, my lord, I pray that no leniency should be shown to this type of, my lord, and other witnesses that are there, my lord. They
How come granted bail the others?
Lordship, the paragraph, Lordship, which my learned senior friend has referred to, Lordship, if we go by that paragraph, it is also revealed, it starts from there till the next, about the assault on the deceased. Not a single line against the present petitioner. The present petitioner is the father, who is
But
aged
others
about
were granted
69.
bail, no?
Others were granted bail. All the other persons were granted bail.
Yes.
I'm not taking that ground as because, Lordship, all the other persons were granted bail, as because, Lordship, the grounds of arrest were not furnished to them. That Bihan Kumar, by referring Bihan Kumar.
Okay, by referring to Bihan Kumar.
Yes, Lordship. If Lordship may kindly take up the LCR for a moment, Lordship, page number 209 and 2010. 209, 210.
LCR.
LCR. 2 persons, that is the present petitioner and one Nizamuddin, both were arrested on the same date. My lord, got it?
Yes.
Now, Lordship may kindly come to page number 207, the arrest memo of Nizamuddin. Both were arrested on the same date. Nizamuddin.
No, now you cannot rely on this ground of arrest, and because we have a new judgment now.
Yes, no, I'm not on that, Lordship. Therefore, Lordship, I'm not going there. My only ground is that, Lordship, the persons, my son, my daughters, my son-in-law, they have assaulted the deceased. This is admitted, Lordship. And all are on bail. I am 69 years old, Lordship. I am in custody since the 167 days, Lordship. And considering my age, Lordship, and as because, Lordship, all the persons are already on bail, Lordship, and Lordship, charge sheet has already been submitted.
You have gone to the CD?
Yes, my lord. Your lordship will say, my lord, just all the flag marks I have made, my lord, but your lordship, just one, my lord, the independent witness, what he has to say, my lord, who tried to check him, my lord, the side flag, my lord. First, that was
Independent witness?
yes.
Okay.
Yes, flag mark, my lord.
Oh.
Others also supporting, my lord. He tried to save them, my lord. He is a very.
Page number 139, my lord. That Altaf Hussain, that is independent.
He resisted everyone to stop, my lord, but they never stopped, my lord. Even the ladies, my lord, they also start joining, my lord.
So this woman died, no?
Women died, my lord.
And
Whether
Lord, that
it is
that-
true or not, no, my lord, nothing, my lord. Just they will assault, and after that they, and the second part also, same.
No. I'll read out.
No,
The
no,
bond was
no,
an
no, Lordship. That is not required, Lordship.
I'll read out.
No, Lordship. Highly apologize.
Item number 33 for orders.
Lordship, my pass over for the time being.
You will POCSO over?
For the time being, Lordship.
Condonation or delay?
Condonation, my lord.
How many days?
118 days.
You don't have 4 certificates, no?
My lord.
You have 4 medical
I
certificates.
am amicus, my lord. They have given a medical certificate.
Lordship, my pass over for the time being. My senior, he has some submissions to make. He has some submissions to make.
I will condone.
No.
Let's check. You have any objection?
No, madam.
See, he doesn't have objection. I'll condone it. Where are your certificates? Medical certificate?
Certificates. Page number, my lord.
Number 8.
Page number 10 and 11, my lord. 10 and 12.
PP has any objection?
Lordship.
Third learners council, Miss Abigail.
A Lala.
Miss A Lala for the petition, for the applicant. Was filed this application under section 5 of the Limitation Act. We have given the wrong year, 2023 Limitation Act. This is 1963. What to do now?
Limitation. Typographical error, my lord.
Okay, see? He's so eager to condemn your delay.
Let the case be hard on merit, my lord.
I don't. Limitation, under section 5 of the Limitation Act, with prayer for delay of 106 days in preferring the appeal against the judgment and order dated 1/6/2024.
Preferring revision, madam.
Huh?
Revision, madam. Connected matter.
Judgment order dated
No, my lord.
criminal appeal 18 of.
No, my lordship has reflected as condoning the delay in preferring the appeal. That's
Yeah,
the revision, madam.
or preferring, okay, yes. Referring the revision, criminal revision petition, against the judgment and order dated 1/6/2024 passed by the learned session judge Johat in criminal appeal number 18/2019 dismissing the appeal and upholding the judgment of conviction and sentence dated 14/2019 passed by the learned additional chief judicial magistrate Johat in CR NI case number CR within bracket case number 273 of 2010 by modifying and reducing the sentence of compensation amount to rupees 2 lakhs under section 138 of the NI Act. It is submitted that the applicant
No, it is 23.
130.
130. It is too much for now.
Srimati Mamuni Sukya Datta.
No, it is complete.
33.
My apologies, my lord. I am not appearing. Sorry, my lord. There are 2 cases. Same party, my lord. So one is item 33 and 35. I have been appointed as amicus in 35, not in 33, my lord.
Oh.
Same name, my lord, so there's some confusion.
So, the other side is not present today.
That case, I have no idea, my lord. Because they're the same name and same parties, my lord, so there was some confusion. My lord, same party, the parties are same, my lord. Mamuni Soikia Datta, my lord.
35?
I mean 35.
Then I'll take up the 35.
35, my lord.
Matter 35. Other side is not present. Item number 33.
We have taken steps, my lord. Let it be condoned, my lord, come for revision because the whole matter, my lord, 2024 matter.
But a private party, no?
No, no,
Let them.
ultimately revision, because it is a condonation matter, my lord. If it is condoned also, my lord, 102 days, my lord.
It will be condoned 102
Yeah,
days.
but warrant of arrest is hanging over me. That's the difficulty, my lord. I'm a lady, my lord. Your lord, if your lordship directs, because anyway, my lord, I have to make the payment, some or other. So your lordship may kindly condone, my lord. So at least endeavor shall be made to make the payment, my lord, on the when the revision will be listed, my lord. Any 10%, 20%. There is let me do.
It'll continue going. 33.
The judgment is of your lordship 2019, my lord. Then they have to appeal it 2024, man, 1624, man.
So let the other side come then.
Let
Let 2019 judgment, let the other side come.
No, not 2024, my lord. Your lordship, the session judgment is of 24, 16/2024.
2024.
Yes.
Okay.
And the check amount is rupees 1,50,000.
I'll just check the office note.
Yes.
Whether respondent has. See, there are orders of other courts also, earlier courts.
Yeah,
They have
that's
not
fine.
condoned the delay. They have not
There's
condoned.
one case, my lord, this just a few weeks. There was these on our court matter that were.
No, see, other 3 orders have been passed.
Yes, my lord.
No ex parte condonation of delay. They have only waited for the service report.
I understand, my lord.
Earlier, the service report was returned without service, then another fresh step was taken.
Yes, my lord.
So I won't go into all
He'll get,
those
my lord, warrant of arrest.
trouble. I won't take the trouble.
He'll get warrant.
No,
of-
no. Let the.
Because there is.
Let me go to
The
the.
coordinate bench of this court has passed similar order, man, in case of a petition.
I won't take that much of trouble. I'll just see the office note.
You understand, but even if it is.
Yeah, why I will not take that trouble? No fresh steps or service of notice upon respondent number 2 has yet been received by the concerned section. So I won't take the trouble. I was about to pass the order because he said he has no objection.
But that was in respect of item 35.
Item 34.
Not this one. If he orders to appear, my lord.
Etu baki kati diya.
So that I will also.
Counsel Mr. P. Kotoki is present for the applicant.
We will now take fresh
yes,
steps that.
Respondent number 2, petitioner, applicant may take fresh steps to issue notice to the respondent number 2. You want a date?
Fresh steps I will be allowed to take, madam.
Yes, fresh steps, yes.
The date may be fixed, madam.
Returnable on?
18 September.
Then we, learned additional PP, Mr. MP Gusami is present for the respondent's date.
Item 34.
You are present in item number 35.
Yes, madam. That amicus curiae has been appointed. madam.
Yes.
That may be condoned, madam.
Here you have any?
35, madam.
This is condonation of.
Condonation.
You just correct the section there. It's 2023, it ought to be 193. Not here in that other,
Okay.
here it's correct.
Correct.
How many days?
118.
118.
You do not have any objection, no?
No, madam. Let it be hard on merit, madam.
Yes. Learned counsel, Mr. P. Kotavi is present for the petitioner. Applicant लिखा. I to लिखी बात.
Applicant.
Learned additional PP, Mr. B, comma, DQ, learned additional PP, Mr. MP Usami is present for a respondent state, comma, whereas learned counsel, Mr. S. Nawaz is present for the respondent number 2, full stop.
As amicus.
As amicus curiae. The counsel for the learned amicus curiae for the respondent number 2 has no objection if delay of 118 days in preferring the revision petition is condoned. It is submitted on behalf of the applicant that the applicant Srimati Mamuni Soikia Dr. was suffering from dysfunctional uterine bleeding owing to uterine fibroid and cyst within bracket polyp, POLYP, bracket close, along with severe anemia since 3/8/2024. Annexure 1 and 2 are the documents relating to the ailment of the applicant. I have scrutinized the documents and the medical certificate issued for the applicant. It appears that sufficient grounds have been shown by the applicant, no mala fide or latches is apparent. The learned counsel for to know reason no. Considering all aspects, delay of 118 days is condoned. The registry may register the connected revision petition.
Item
34. Highest test disposed of.
May I plead the the criminal petition of quashing of a proceeding against the accused petitioner, who is the accused number 3 in the trial court, Here, he is the accused number 3 in the PRC case, In the last occasion, we are directed to, we are directed.
Number 3 is what? For the third
here,
time, I cannot hear you.
the petitioner here for
No, the accused number 3.
he is the accused number 3 in the trial court before
Okay,
the trial
in the
court.
trial court.
Before the trial court. Today is a fix for orders upon the steps upon the response number 2, which is complete, office note 11/8/2025,
You are for respondent number
I'm
2?
for a respondent state,
State
respondent number 1.
11?
11/8/2025, 08. In the second portion, flag X and Y, it says, it is delivered to the informant who lost the affair,
Okay.
Here, the page 121, NBW and proclamation has been issued against the petitioner, till the disposal of this petitioner, kindly allow him to, appear before the court, by setting aside the NBW order,
So what has happened, my lord, I seriously doubt whether this petition will be maintainable or not. The reason being that there are 3 charge sheets in this particular case. The petitioner has, if your honor kindly, if your lordship kindly see the index part, at serial number 6, the index part, at serial number 6, the copy of the original charge sheet being number 22/22. This is the first charge sheet. Then the second charge sheet, Annexure 5, copy of the supplementary charge sheet 2B, the index part. Now there are 3 charge sheets filed on 3 different dates.
Annexure which one?
Annexure the index part,
Annexure which,
the index part,
number, serial number?
serial number 6 and 7,
No, 4 and 5, 4 and 5 question.
like 6
Serial
and 7.
charge sheet, supplementary charge sheet, yes.
Supplementary charge sheet, one is the copy of the original charge sheet 2/22, and the one of the supplementary charge sheet, copy of the supplementary charge sheet 2B and 22. So there are 3 charge sheets. The 2A is missing, where the role of the accused A3, Rafiur Rahman, the present petitioner, has been described. It's a gross suppression of material fact because he is well aware. Now, if your lordship come to the prayer portion, lordship may kindly come to the prayer portion. Prayer portion at page 23.
Yes.
Paragraph 23. May I read that particular? It starts from emanating. That is at the pipe. Top from the top. Emanating from PRC case number 547/22, along with charge sheet dated 7/2/22 and supplemented charge sheet dated 12/5/22, has been filed by the respondent authority against the petitioner herein accused number 3 in CIDPS case number 13/2021. He is talking about the accused number 3. He is well aware that he has been arraigned as accused number 3. Now, where the accused has been arraigned as accused number 3, the charge sheet he had annexed, it shows the other accused persons. His name was not there. So he had deliberately suppressed charge sheet 2A, where his role has been surfaced. And I seriously doubt about the maintainability for another reason. Now the case is at the trial stage where the supply of copy under section 207 has been fixed by the trial court. And the next date is coming on 24/10. So at the stage of supply of copies, without getting the prosecution papers, how can he challenge the entire criminal proceedings without getting appropriate knowledge about the prosecution papers? You have to lay down the proper facts before the court. Say, for example,
He's not pressing these prayers.
absolutely.
He only he's submitting to get the PNA and WA to be kept in abeyance or to be cancelled so that he can appear and cooperate with the trial.
Lordship, there are 2 aspects. Since he has challenged the entire criminal proceedings and the PNA as well as NPW,
now
he wants to set aside.
That.
No, for that purpose, page number 127 will suffice.
This petition won't be allowed.
That is.
It will be disposed of with a direction that he will cooperate with the trial.
Absolutely, absolutely. That is my point. Your lordship may kindly turn to page 127. That is your lordship's order passed in a similar case. He had annexed it. In the same case, paragraph 5, 127.
The same petitioner.
The same petition, no, not same petitioner, but in the same case, another petitioner.
Accused is different.
Accused is different. Paragraph 5. To cut short, as this case is pending for a prolonged period and as the petitioners are willing to cooperate with the trial, I have taken a pragmatic view. The NBW and a proclamation issued against the petitioner is hereby kept in abeyance for 1 month, and the petitioner is directed to appear before the learned trial court within 1 month and cooperate with the trial. If he is pressing for that, I have no objection.
I'll pass the same order in terms of the above observation and nothing more.
Absolutely.
This is what he has submitted.
Absolutely. That can be done. But only the thing is that he has challenged the entire criminal proceedings without getting the copy of the prosecution papers, the charge sheets, as well as the 161 statements and the other documents.
If this is a criminal petition, my lord, even the record will be also called for, my lord. Even I have not received the copy as edited by my learned senior counsel, my lord. Therefore, whatever I have received that I have annexed here. Even the, my lord, before hearing the final, my lord, this entire criminal petition, the record will be definitely called for, my lord. Even I have to ask for the set aside for the PRC project.
I'll dispose it of. I'll direct you to appear or you want to challenge it?
Dispose it of.
The final, that last submission I heard was that to keep these two PNA and the WA in abeyance so that you can appear.
My
So I'll pass a similar order.
My lord.
He'll get a copy, then only he can ask for any other order, means any other reliefs before this honorable court. Because unless and until he get these particular documents.
No, I'm only asking him to appear before the court.
My lord.
Etu enake likhi diba,
Just
to-
one line, my lord, maybe because I have already filed the criminal petition by challenging the my lord, entire proceeding, my lord. And one liberty may be that's given, my lord.
What liberty?
My lord. Again, approach after receiving the copies, my lord. I may, my lord. Again, approach before the honorable court.
You're not withdrawing, no? If you withdraw, then I can pass an order for liberty, but now I won't pass any order for
My
liberty.
lord. Then, my lord, I'll
Similar order,
Similar order.
like the one I have passed.
Yes, madam.
Third learned counsel, Mr. Yone,
Yes, sir, very come.
S. Hazarika for the petitioner. Rafiqur Rahman, who has filed this application under section 528 of the BNWS 2023 with way for quashing the PRC case number so and so, along with charge sheets dated 7/2/2022 and 12/5/2022, arising out of CID PS case number so and so registered under so and so sections. Heard Mr. Yone?
J. Hassan.
J. Hassan, learned standing counsel.
No, special public prosecutor.
Learned special public prosecutor CBI.
No.
CID.
CID.
For CID. Who has raised objection against the prayer for setting aside and quashing the proceeding of PRC of the aforementioned PRC case, full stop. It is submitted that the petitioner has not annexed the relevant charge sheet laid against the petitioner, but the other two charges have been annexed along with this petition, in which no charges have been laid, in which other two charges have been annexed along with the petition, in which the petitioner has not been named as an accused.
No, it is.
No, it was named in the accused. Conspiracy angle was there, but he was not arraigned as accused number A3.
Well, it is there.
Wherein the petitioner has not been arraigned, not been arraigned as accused number A3, full stop. Which is contradictory to the submission of the petitioner, full stop. The petitioner is willing to appear before the learned trial court and cooperate with the trial. The petitioner has also therefore prayed to set aside the order of issuing NBWA and
Proclamation is also there.
against the petitioner.
Page 121, madam.
Wide order dated
Ballot 30/10/2024, madam.
Subsequently, the other orders have also been passed because there is a standing warrant against him.
Okay.
That is reflected in this particular order where the standing warrant has been issued. Because this was when this petition was filed, this petition was filed long back.
Okay.
Subsequently, certain developments were filed. Even if this order goes, the other order
Standing
remains.
warrant will always be there.
Yes, that will be there.
Madam,
Because
20, what is the date?
30/10/2024 is the first order. Then after it was, madam,
30/10/2024 and subsequent orders of and subsequent similar orders, full stop. I've considered etu iapa copy kori likhi diba. Page number
127, madam.
page number 127, paragraph 5 or paragraph 5 to likhi diba. Any other ground?
My main ground is that the whatever money has been transferred to me, my lord, as a small I'm
No,
not
no,
senior
no,
finance.
no technicalities.
No, my lord, there is no.
like that.
Only a liberty.
Paragraph 5 or 7.
Only liberty may kindly be granted, means not liberty exactly. The court might take into consideration that even in the event of not appearing, means prior to 1 month or on or before 1 month.
Passes to cooperate with the trial. If he doesn't cooperate, then
Court will take steps.
yeah, consequences will follow.
Yes.
Cooperate with the trial.
My lord, the NBW and the proclamation has been set aside.
Yes,
till-
yes, not set aside.
My lord, till-
Abeyance.
Abeyance till the.
Same order, similar order
Same.
for 1 month.
Right.
So you appear for
Right.
within 1 month.
Right.
You're from this place.
No, my lord, he's in Kerala, right?
Okay, then I'm giving you 1 month.
Right. I'm deeply over.
Well obliged.
Item 36. Office note indicates that service is not complete. Office note indicates that ID card is not returned back. May we await certificate of
Service report on whom?
all lordship, sole respondent,
Learned standing counsel
NCB.
for whom?
NCB law.
Yeah?
NCB.
NCB, Mr. SCKL is present. Service report on the respondent is awaited. List the matter after
2 weeks.
2 weeks.
Not. Item 37.
Ma'am, I said it to 9:37 আছে. Well, this is.
Bail,
Yes, my lord.
bail in appeal.
In a criminal appeal, my lord. The IA is there, my lord.
Why? We can hear the appeal.
No, we can all hear it, my lord, but in the meantime, this IA is not hearing itself. And when will the appeal come, God knows better, and we have seen from our experience also, what is the state of the registry, my lord, to be honest. I'm not casting any aspersion, but I'm forced to say. So I'll praise my IA, my lord. Or if your lordship want, because it
Yeah,
takes
ask
some
for
time.
how many days?
Because he is in for more than 175 days, my lord. And the
5
offense,
days, and I can extend to another 5 days. How
no,
much time do you want?
if your lordship is convinced with the length of detention, my lord, and what is the sentence? The maximum sentence was awarded by the trial court in a POCSO case for 5 years, my lord. Only inappropriate touches were given. And if your lordship will kindly see.
The same prayer. Lordship, it is a very petty matter, Lordship. What happened?
Your notice has been served, no?
Notice has been, we have taken steps, Lordship.
Notices were issued by registered court with
Yes.
AD on, not served.
Lordship, Lordship may pass an interim order, Lordship, because of the fact that.
No, in the, we'll have to take up a hearing. So
Lordship,
I do not have time.
then Lordship, for that may be fixed for hearing.
Yes,
Yes,
can we
Lordship.
fix?
At the top of the list, because on third occasion, it doesn't release, Lordship.
Actually, they are fixing matters in a manner,
Yes.
see, everything is in motion, admission, so many cases together in admission motion, and everybody I have to,
Yes.
any court has to hear,
Yes.
hear. If you are pressing for interim, then we will have to fix a date.
Third of September.
Otherwise, if on order as usual, then I can,
Lordship, fix a date for hearing, Lordship.
3rd September.
3rd September. Due to paucity of time, matter cannot be taken, list this matter
3rd of September.
on 3rd September, same date December.
No, beleg
Lordship, with time,
First
yes.
On the third, on top of the order list, orders list.
Lordship, obliged.
May please, your lordship, item number 39, lordship.
Mm.
Date may be fixed, lordship.
Lordship 25.
No. Female petition 25, no, cannot fix date.
Item 45, my
It
lord.
must come in usual course.
Item 45, my lord. Appellant already spent half of the period in jail, my lord. There is urgency, my lord. A date may be fixed next week, any date, my lord. Half of the period already in jail, my lord.
Item 45 to date, I did it.
45 on 4th September.
4th September.
42, no, sorry, my lord, 42.
42.
Oh, 42.
42, my.
4th September.
my lord.
42.
I,
42.
for suspension of.
Which one?
suspension bail.
Item
I have
number?
item 4040. That can be
40.
given, my lord. Here is,
You want a date?
yes, my lord. short date, my lord, because he has been behind the bar for 165 days, my lord.
On 5th of September.
Oblige, lord.
Item number 45, Lordship. Is a condonation of delay matter, Lordship. Notice may be issued also.
45 to days, 45 to days. 45. First day,
First is 49 days of delay, Lordship.
applicant to take steps to issue notice to the, this is civil or criminal?
Criminal, Lordship.
Criminal, why do you want notice? I think he will not raise any objection.
No, Lordship, respondent number 2, Lord.
Oh, okay. Applicant to take steps to issue notice to respond number 2. Yes, 4 weeks. List, no, 2 weeks. 2 weeks. List after,
2 weeks, Lord.
list after 2 weeks, yes.
My lord, item 43. This is a application we have filed for correction of an order that was already passed in criminal petition.
43. Which one?
This Jimma petition we have filed in criminal petition now. We have prayed for a correction in the order. That is the car number, vehicle number, which was wrongly recorded in the order of criminal
Wrongly
petition.
typed in the order.
Yes.
Okay. I'll allow it. Size and get PP.
43.
43.
Otherwise, I have no objection.
Learned Counsel Miss
Aroy
has filed his application on behalf of the petitioner Sri Jogo Mohan Bora, petitioner and applicant, who has filed his application under section 528 of the BNSS with prayer for correction of the typographical error in the order dated 28/5/2025 passed by the which court?
Honorable court.
Or by this court, passed by this court in criminal petition number 282/2025. Full stop. Part Mr. R. Kaushik, learned edition PP Assam. It is submitted that the order, in the order,
the vehicle number
was mentioned as erroneous, mentioned as
AS 01EG 0951
instead of
AS 21Z G 6352.
Considering the submission, wherever the words and the figures AS01 EG
AS01 EG 0951
appears, it may be typed and corrected as AS21 G 6352.
Yes.
In terms of the above observation, this application stands disposed of, and this application will form a part of the order dated 28/5/2025 in criminal petition number 282 of 2025. Okay.
May I please, Your Lordship? My lord, item number 46, the only hearing matter. Item number 46, the hearing matter, Lordship. I am Lordship, I am waiting for the respondent. But a date may be fixed, Lordship.
9th of September. See, this won't bench be there. This bench won't be there.
Lordship.
So I am fixing orders for somebody else, and they won't mind.
Item number 44. It's the NI Act case. He's already in bail. I have filed a miss case for remaining in previous bail.
What do you want?
NI Act case.
Yes, what is your prayer?
He's in bail, but a sentence has been to suspend.
No, I cannot take up today this matter.
He made on previous bail.
I'll fix a date. Today I cannot take up this matter. I'll fix a date. This is the
2nd September.
Due to paucity of time, leave this matter on 2nd September. Anything else?
Lordship, only 41 to 30.
41 to October for you. Huh?
2 weeks TDR.
কোনবা আছে নি for anybody for 40?
TDR is 24. But TDR applicant mentioned this.
Oh, acha, date to DDA date. Oh, 2 weeks.
2 weeks. Item 41.
2 weeks করে দিও। 39 হয়েছে 39 39 2 weeks